Hello, everybody. Of course. Of course. There's our baby girl right on cue. She just knows. She knows she's going to get her treats. She knows she's going to get pets. She knows she's going to get all the attention for a hot minute. She's got me trained. Oh, I'm so happy to be here. I literally spent all day working just on this. Yep, I had to. It was a good one. I had to do this. Hello, C-Rex, honey. Hello, Casey Battles. I love you. Hello, Mortimer Duke. Hello, Buzzy Pug. Yay! I hope you're healing well, sweetie pie. Howdy do to you too. Who else we've got in here? Hello, Micah Psycho 1. Hello, Martha D. Great to see you. Hello, Jerry Matthew Boyd. Hello, Tiana Miller, honey. I've missed you. Hello, Linda Applegate. You are too sweet to me. Oh, where'd the third one go? Did I give you 3? Did you have 3? Tell the truth now. I think I gave her 3. I had them counted out, but I wasn't counting when I was handing them to her. The kitties have their food right here because they were, well, Billy was all over my keyboard. Yeah, so I didn't want to give him treats because he's chunk butt. So I just put some kibble out, and I think I fooled him. Maybe not, because he didn't eat the entire pile. If it was treats, he would have eaten the entire pile. Hello, Spider-Man. How you doing, love? It looks like you're doing well. Oh my gosh, congratulations, though. Oh, thank you, Martha D. I couldn't do this without you guys, though. You guys make the show. All right, you ready? We're going to start off with Judge Ricky. For the majority of it, actually. It is 2 defendants for the same crime. Well, same circumstances. We'll put it that way. I have all of the first defendant, but I only have the sentencing of the second, which, all of the circumstances are the same. So we'd essentially be watching, everything in duplicate anyways. So just jumping straight to her sentencing, it makes perfect sense in context. So we are going to watch. It's insane. It's absolutely insane, you guys. But we're here for it. We are here for it. Oh yeah, going back to 24.
Number 2024, CR 346. Member Norris appears for the state of Kansas. James Watts is defense counsel. Wendy Scott appears at the Butler County Jail Zoom location. This matter comes before the court at this time for evidentiary preliminary hearing. I trust the state's ready to proceed. Ms. Norris?
Yes, Your Honor, and I did notice the defendant was just raising her hand a moment ago. I don't know necessarily what that's about, but I just wanted to bring it to the court's attention before we got too far down the road here.
I would like to talk to my lawyer before we start this.
You haven't talked to her, Mr. Watts?
I spoke with her.
He spoke with me Thursday and I didn't.
Yeah,
We had stuff that we had said then, but I have not heard from him since, so I'm trying to figure out, can I talk to him on a breakout or I don't know if that
I'll
works.
allow it. I really need to get started with this evidentiary hearing if we're going to have one, but
Okay.
Mr. Watts, I'll allow you to have a short breakout session with your client at this time. So we'll recess briefly for that purpose. Mandy, if we're still recording and broadcasting, we will resume. If not, please put us in position to resume.
We are still.
Very well. Following a recess period in this case to allow a breakout session between defense counsel and the defendant, we resume proceedings in State versus Wendy Scott. Ms. Scott, Mr. Watts, Ms. Norris appearing as before. Mr. Watts, is there any announcement to be made at this time?
not at this time, Your Honor. Thank you. We're ready to proceed to prelim.
Very well. And the state may call their first witness.
Thank you, Your Honor. The state calls Brian Dunlap.
Mr. Dunlap,
Yes,
you'd raise your right hand, please. I will administer an oath. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right. May question the witness, Ms. Norris.
Your Honor, would ask the witnesses be sequestered, please.
All right. Any subpoenaed witness who's on this meeting other than Mr. Dunlap needs to be sequestered. We'll put you in a waiting room and we'll call you in when it's your time to testify. Mandy? All right. You may begin your questioning now, Ms. Norris.
Thank you, Your Honor. Please state your name for the record.
Brian Dunlap.
And Mr. Dunlap, you live in Butler County?
Yes.
What area of the county do you live in?
I live just south of the Augusta Airport.
Okay. And were you living there in July of this year?
Yes.
And do you recall July 20th of this year?
Yes, ma'am.
And why do you recall that day?
From the events that happened around 5 o'clock or so, I had a woman knock on my door, and when I answered, she was distraught. So I called 911 to get the police department there.
Okay. And did you know this woman?
No,
Okay. And was she, you said that she was distraught. Was she injured or,
yes.
and explain to the court what sorts of injuries that you seen?
I believe it was on her left arm. She had some lacerations and was bleeding. And I did offer to help clean up the wound. And at that time, she did not want it, want the wound cleaned up. She wanted the police department to see what happened.
Okay. And did she explain to you what happened
Yeah.
to her?
Yes, she did.
Okay. And did you tell 911 what she had told you, or did you just call 911 and then they just sent somebody out?
When I called 911, I was interpreting what she was telling about her story to the 911 operator.
Okay. And just a brief synopsis, what did she tell you had happened to her?
She told me that there were two ladies that came to her apartment. One of the ladies was holding her stomach, saying she needed to go to the hospital. So Beverly gave them a ride, and then they were giving her directions. And at some point, she mentioned to them, "This is not the way to the hospital." And at that point, she said that they threw her out of the car and stole her car.
Okay. And were you able to figure out about how far away she was from? I mean, was this right by your house or?
No, she had to walk at least a quarter to a half a mile to make it to my house. There's another house within eyeshot of my house, but it's probably 3 blocks or so. And there was nobody there. She went to that house first. And then she saw my house up on the hill and she walked up to my house.
Okay. And did she identify herself at some point to you?
Yes. I mean, yeah, after so I had to put my dog up. He doesn't let anybody come in the house. And so I put him up, and then when I came back, I would start asking her questions. And she told me her name, how old she was, and she was pretty distraught. She was definitely in shock when I talked to her.
Okay. And what did she tell you her name was?
Beverly Zilke.
And how old was she or is she?
I think she said she was 85, 86.
Okay. And did you talk any further about what had happened with
Yes.
her?
Yeah. I mean, when the sheriff's department got there, she had to tell the story over again. And like I said, she was definitely in shock. So the story was kind of, I mean, she said the same things, but there were, how do I say it? There were instances, input that she didn't tell me in the beginning. Like, she had her daughter's dog with her, and they somehow kept the dog. They threw her out of the car and then just took off with the dog. She was pretty distraught because she was dog sitting for her daughter. That was one of the things I remember. Can you repeat the question?
Oh, I just want to know if there was anything else that you talked about about what had happened to her and anything else besides the dog that
Oh, I
stands
do.
out.
Yeah, she did say that one of the girls threatened that she had a gun. And at that point, I think that's when they kicked her out, said that she would kill her.
Okay. And this whole time, that, about how long do you think she was at your house, Miss
It
Zilke?
was over an hour.
Okay. And was she in the same state most of the time that she was at your house?
Yes, she was she was in shock. Yeah.
Okay. Yeah, and you mentioned before shock, distraught. Was she crying or did she?
Really, I mean, she's a strong woman from what I can remember, but the only time she really cried is when she was worried about her daughter's dog.
Okay. And did she have you call anyone for her besides? I mean, obviously you called 911.
No, because she didn't have her phone. They had her phone, so she didn't remember the numbers.
Oh, okay.
I do know that the sheriff's department called her or had her call her bank to shut off her credit cards because she was worried about them using her credit cards.
And when she came to you, did she have anything with her?
No, no, just the clothes on her back.
And once she left your house, did you have any other involvement with the case or with law enforcement?
No, I haven't.
Okay. And so when law enforcement was there, did you basically kind of explain what you and I've been talking about here, about how she ended up at your house, etc.?
Yes, yes.
Thank you, Mr. Dunlap. I don't think that I have any further questions for you. Your Honor, although I may need to have him stick around for possible just identification, but otherwise, no further questions, Your Honor. Thank you.
Mr. Watts, any questions for Mr. Dunlap?
Not for this witness, Your Honor. Thank you.
All right, Mr. Dunlap, I'm going to have you go ahead and stay with the Zoom meeting. I'll ask you
Okay.
to mute yourself at this time. Until your release, I'm going to ask you to stay with us. Okay?
Okay. Yes, sir.
All right. Are you asking that he be sequestered again as well, Mr. Watts?
Please, Your Honor.
All right. We'll go ahead and put you in a waiting room, Mr. Dunlap, in case you're recalled later. Thank you. Next witness, Ms. Norris.
Your Honor, the state calls Beverly Zielke.
Beverly Zielke? Okay, you're muted right now. If you could take your mute off. And if you could change your camera angle where we can see your entire face.
Unmute. There we go.
Hello? Hello?
All right, Ms. Zielke?
Yes?
Is there any way you can sit up or change the angle of your screen where we can see your entire face? There, that's better. That's better. That's fine right there. Ms. Zielke, I'm going to administer an oath to you at this time. So I'm going to need you to raise your right hand.
Raise your right hand.
You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God?
I do.
All right. Ms. Norris, you may question the witness. You can put your hand down, ma'am.
Ms. Zielke, can you hear me?
Yes, I can.
Okay. And please state your name for the record.
Beverly Zielke, Zielke.
And Ms. Zielke, in July of this year, where did you live?
Oh,
Where were you living when that happened?
oh God. Well, I lived in the Union Mills apartment complex.
Okay, and that's in Wichita?
Yes, it is.
Okay. And do you recall an incident on July 20th?
What incident are you referring to?
Did you have to talk to law enforcement on July 20th about something that happened to you?
Yes.
And can you explain to the court what happened to you on July 20th?
Well, it's sort of a long story. Do you want to hear everything?
Yes, ma'am.
Well, the girl that lives in the apartment complex called and asked if she could come down and look at a cookbook. And I said, well, yeah, that would be fine. And the other girl's name, I think is it Elizabeth? Is it the small girl that lived in the same apartment complex in Union Mill apartments? And so I thought she'd come. The doorbell rang, and it was I didn't know her name, but I found out today it was Wendy. And she came, she said, is she here yet? And I said, no, she should be here anytime. It was shortly after the other girl came. And Wendy and I sat in the living room and just chit-chatted about small talk. And the other girl was in the room with the cookbook in a bedroom in the very back of my house where I have a bookcase. And finally she said, she's taking a long time. I think I'll go back and see what she's doing. I said, oh, okay. And she went back there, and it was quite a while. And I thought, my lands, what's going on? So I got up, went down the hall, started to open the door, and it was locked. And I thought, huh. And I tried it again, and it unlocked. It was unlocked. So I went in, and the other girl was sitting on the floor looking through the cookbook, and Wendy was standing there just kind of watching her. And she finally continued to watch, and then she said, all of a sudden, just out of the clear blue sky, she started rolling. She said, oh, and rolling on the floor. And Wendy said, oh my God, she's having another attack. She needs to go to the she needs to go to the emergency room. Could you possibly take us there? And I said, well, yes, I'll do that.
At that point, I would have been like, nope, this seems so serious. Let's just call 911.
And so we all got down and got in the car, and the thin girl sat in the, is her name Elizabeth? I think someone told me it was the thin girl, and and Wendy, the heavier set girl, she got in the back seat, and we went down Rock Road to the highway and started going on the highway and turned to go to, and it was towards Andover. And I know there's 2 stoplights, was one, and then the second you turn and go down the street to go in Andover. And when we got to the first one, I was started to go, and she said, no, turn here. And I said, that's a country road. And they said, yeah, it's a shortcut because her insurance won't be accepted at the other place, and it will at this other place that we're going to. I said, okay. So we started going down the country road and went and went and went and the road and road. And I said, where is this place? We've passed Andover. And she said, don't worry, it's down the road more. And I went down and finally I just stopped the car and I said, I want to know where we're going because we've been on this road a long, long time and we should be there. And all of a sudden that Wendy held her purse up and she said, see this purse? I said, yes. And she said, I have a gun in it and I will use it. And then I said, she jumped out of the car and yanked my driver's side door open. And I also had my daughter's dog because she was in the car, little Chloe, because I was babysitting because my daughter went on a cruise. And so I was babysitting her dog. And she grabbed my hand by the door, which would have been my left hand, and she started pulling it and pulling it and pulling it. And she had long fingernails and they cut into my skin all the way down. I ended up having blood running. I had blood running clear down my arm. And the other girl was the thin girl that lived in the apartment. She was pushing me from the back and Wendy was pulling my arm and yanking me. And I was trying to hang on with my right hand to the steering wheel and stay in the car. And they said, get out of the car and give me your purse and your car. And I said, no, that car belongs to me and so does my purse. And she pulled me out and my whole arm was blood. It was all bloody. And when they threw me in the dirt, when I stood up, I had blood all down my arm and the dirt was stuck all over the whole entire arm. And I finally they zoomed off in the car and I didn't know, and I was yelling when they were driving off. And I said, where is Chloe? Where is Chloe? And they were already gone. They didn't care. I didn't know if they took Chloe or if Chloe was out of the car. I walked around. I couldn't find her. I finally started walking down the road and I went to a farmhouse that I came to and knocked on the door. They were not home. So I walked back out in the road and I walked on down quite a ways to another farmhouse. I went to the door and knocked on the door and the man answered and I said, I need to call the police. I was just thrown out in the dirt in my own car and they took off with my purse and my car. And I said, I need to have the police. He said, oh my goodness, I'll call right away. And so they called, the man called the police, and I sat on the front porch, and then here come the fire truck, and they wanted to know if I went to, and the policeman and the sheriff, and they all came in the driveway of the farmhouse where I stopped at. And I said, no, I didn't need to go to no hospital. Finally, the fire truck left, except they treated my arm. They washed it all down and put medicine on it and put bandage on. No, wait a minute. They washed it all down and they put medicine on it. I don't remember. I don't remember whether they they put some bandage on the bad part of just a Band-Aid on a couple of them, but the others were they were basically clear. And
Okay, Ms. Zielke, I'm going to go ahead and stop you right there. I'm going to see if the attorney has any other specific questions for you. Ms. Norris, do you have a question to ask her?
Yes, Your Honor. Ms. Zilke, when you say country road, do you mean gravel road?
well, it was out in the
Not paved?
country. It was out in the country. It was not paved because I had dirt all over my whole arms when I stood up because my whole arm was bloody. Blood
Okay.
was coming out of all down my whole entire arm.
Okay. And the person that's, and real quick, I'll ask this question first. When you're looking at your screen right now, do you see just me or do you see multiple people?
I see multiple people, 1, 2, 3, 4, 5 people.
Okay. Now,
6,
Ms. Zilke,
7.
do you see the person that you identified as the heavier set girl that I think you've been referring to as Wendy on the screen?
Yes, I see one Negro girl, and that's
One
her.
Negro girl, so that presents to me.
Okay, so do you see the person that you've been referring to as the bigger girl and Wendy when you were talking?
Yeah, yes.
All
Can
right,
you
Ms.
say
Ms.
what color she's wearing and maybe what the title in the corner of the box is?
But she's wearing orange,
Okay,
an orange.
and Your Honor would ask that the record reflect that the witness has identified the defendant, Wendy Scott.
The record so reflects. Ms. Scott, hold your commentary.
And Ms. Zilke, how old are you, or how old were you in July?
86 years old.
Okay, and what kind of car?
I had a brand new car. It was a brand new Altima Nissan, so it's this year's.
Okay, so a 2024 Nissan Altima.
Yes.
And do you recall what you paid for it?
Well, I don't remember. I used my other car as a trade-in, and it was quite a few $1,000s.
Wait until you find out the reason she wouldn't go to the hospital.
Do you recall if it was over $25,000?
Yes. Oh, yes.
Okay. If there's someone with Ms. Zielke, I'm going to caution them. They are not to help her or to assist her in any way by providing any information to her. She needs to testify on her own today. So I'm going to make sure that there's no one else who's testifying other than Beverly Zielke. So re-ask a question, Ms. Norris.
Ms. Zilke, was the car, did you purchase it this year?
Oh, yeah. It's brand new.
And so did you pay more than
I haven't even had it a year yet.
and did you pay more than $25,000 for that car?
You know what? I can't remember. Honest to God, I can't remember. I paid, I know
Don't be looking to anyone else to answer, Beverly.
they gave me there's no one no one in here but me.
Okay.
They gave me a $14,000 trade-in, and I paid the rest cash.
And do you recall if the amount that you paid in cash?
I do not. I could get that information if I go out to the Nissan dealership, but I don't remember what I paid.
That's all right. That's all right. Now, Ms. Silky, when this is going on, were you in fear for your safety?
Well, yeah, when they pulled stopped and jumped and pulling my arms and shoved me out in the dirt and zoomed off in my car, definitely. I was terrified. I didn't know what was going on.
And do you recall anything else that's Wendy said to you about the gun, or if she was going to use the gun?
She said, I've used this before and I will use it again. That's how she said it to me.
Okay. And besides the scratches that the nails did you have any other injuries from the ground or the rocks, or I guess maybe even the fall, or the whole pushing and pulling on your body?
My whole arm was just ripped. I'm assuming she had long fingernails, and when them pulling me, it just tore my whole skin up. My whole skin, even the fire truck and things that came out and cleaned all of them up. Noticed the whole thing was all done. They had to clean my whole entire arm, and they put some kind of medicine on it, and they just cleaned up the whole arm and stuff.
Miss Silky, did you end up having to go get any additional medical attention from
No, I
this
didn't.
incident?
No, I did not.
Okay, so you didn't end up with any broken bones
No, I
or
did
anything
not.
like that?
No, I did not.
Okay, well, that's good. And Miss Zilke, based on how you were explaining it, you did not give them any permission to take your car or your purse or your daughter's dog.
Definitely not. They threw me on the ground and just took it. I could not believe it. I was hanging onto the steering wheel with everything, trying to stay in the car. And the other girl was shoving me from the back, and Wendy was pulling my arm from the other. She was standing with the driver's door open, pulling my arm. And I was trying so hard to stay in the car. And they said they were going to take it. And I said, no, this belongs to me. No, you cannot have my purse. Because I said, give me your purse. She said, give me your purse. Give it to me now. And I said, no, it belongs to me.
Okay, next question, Ms. Norris.
Thank you, Miss Silky. I don't think that I have any other questions. But Mr. Watts, the defense attorneys may have some follow-up questions, okay?
All right.
Thanks.
Mr. Watts, do you have any questions for Ms. Zilke?
I do, Your Honor. Thank you. Ms. Zilke, how you doing?
I'm fine.
Okay. Now, you mentioned that basically some persons came to your door, correct?
What did you say?
You said that some persons came to your door?
Some persons?
That day?
Wendy came to my door first.
Okay, let's talk
Which I
about
was
that.
shocked because she wasn't with that the other girl that lives there. And she said, do you mind if I come in and
Okay,
wait
ma'am.
for her?
Ma'am,
And
hold
I
on a
said,
moment. Ma'am,
well,
ma'am, hold a moment. You mentioned you've used that name Wendy several times. How and when did you learn that this person's name was Wendy?
because today I learned it.
Okay.
I didn't know it before, but I learned it today when we were calling in and stuff, trying to set everything up to get on the TV the internet with you.
Okay. Now, Wendy was there. The person you describe as Wendy, you name as Wendy, was there. There was another person there, correct?
Yes, that was her good friend who
Okay.
lived on the same floor as I did, but she lived down further down the hall from me. And
Okay.
I
Ma'am,
know her last
thank you.
name is Rogers because they told us that, but I don't remember what they said her first name was.
Okay. Who told you that?
Well, when I talked to the sheriff,
Okay, so the sheriff told you her name was Rogers.
Yeah, yeah.
Okay. You said this is a person that lived on the same floor with you?
Yet she lived on the same floor, but way down the hall from where I lived.
Okay. Was she a person you were familiar with?
I had recently just talked to her. I didn't really know her, but I had talked to her uh, because she was sitting in her car crying,
Okay.
and
Is this a person
that's
you knew by name?
no.
Okay.
I had no idea what her name was. I'd never met her before, never talked to her before.
Well, I'm talking about the lady that's there on your floor. I think it's been described as the thin person. Did you know her by name?
Well, that I understand her name is Rogers, her last name.
Well, I
That was the
understand,
thin girl.
ma'am, I understand that's what you've been told her name is. Did you know her name that day?
No, not until I was not until I was told.
Okay.
And I didn't really know her, and I forgot her name because
Thank you,
I
ma'am.
didn't really know her.
So this person you called Wendy came to your door and asked to step in and wait for the other person. Is that correct?
Yes,
Okay.
which shocked
What
me
time would-
because,
Ma'am, what time would this have been?
oh, I don't recall what time.
Was it
Uh,
early afternoon, late
I
afternoon?
would say it was early afternoon.
Okay.
Uh,
And you testified on direct that basically this person you've called Wendy came in and waited on the other person and the other person followed shortly after. Is that right?
yes, yes, and that's true.
Now, this other person, if I understood your testimony correctly, went into a back room to look at some cookbooks. Is that correct?
That girl that has the name Rogers, she went into the back room to look at cookbooks.
Okay, so you went to the back room to look at cookbooks. How long was she back there?
I really don't recall, like, maybe 15 minutes, because the Wendy sat in my living room and I sat there and we talked back and forth that, and then Wendy said, wonder what's taking her so long. I'm going to go back and check out and see what's happening. And
Yeah.
she went back in that room, and I
I'll stop you for
sat.
a moment there, ma'am. When you went back in the room, did you go back or did Wendy go back?
She went back there
Okay, so
alone.
Wendy went back there. Did you go with her?
No, I did not.
Okay. Now you testified on direct that when you went to the back room or someone went to the back room, that door was locked. Is that correct?
Okay, then they didn't come right back, and I thought, well, what are they doing? So I got up and walked back down the hall, and I put my hand on the doorknob, and it was locked. And I turned it again, and it was unlocked.
Okay.
And so I went in, and and the thin girl was, I think Rogers, and she was on the floor looking through a cookbook, and Wendy was standing, just looking down, and they were talking about a recipe, and that's all it was.
Okay. Would you describe this thin girl for me? How tall was she?
Well, she had her hair in those long kind of braids all over her whole head, those big long braids.
Okay.
Um,
Was she taller than you or shorter than you?
she's a very petite, small girl.
Okay. Black or white?
What?
Black girl or white girl?
Oh, they were both black girls.
Okay. Was she heavy set or well, she said she was petite, so
She's
thin?
very petite and small, thin.
Was she taller than you or shorter than you?
Well, I don't know. I never really thought about it. She's just a small frame girl.
Okay.
She's very petite and small.
Look, Watts, the woman met the girl a few days prior crying on the steps, and then the next thing you know, the girl asked her for a cookbook. Like, how much attention do you pay to every person that you casually run into? Leave this poor woman alone. I know he's just doing his job, but she's been through some trauma, and she deserves some compassion.
Okay,
She's,
Now-
I would say she was, I wouldn't be, I can't say because I don't know for sure.
Okay.
I would be guessing.
okay. Now, you testified that the thin girl, this person you've named as Rogers, acted like she was injured or hurting, correct?
Yes, all of a sudden she started laid back and started moaning, and then she rolled back and forth. Oh, my stomach.
Okay.
Oh,
Now-
and Wendy said, "Oh my, we need to get her to the emergency room. Could you please
Okay.
take us to the emergency room?"
Okay, and about what time would you have left? Do you know?
I have no idea. I don't recall that. Honestly, I don't. But we left
You
right
indicated
away.
that- Ma'am, just wait for me to ask a question, please, okay?
Okay, I'm sorry.
You indicated that basically it took you out of the country claiming that they were going to a hospital, correct?
Yes, oh, definitely. We were
All right.
taking her to an emergency room,
Ma'am?
so I thought, and I was
Okay,
told.
Ma'am, thank you. Now, and you indicated these people then threw you out of your car and left you, correct?
They sure did.
Okay. I want to hit or talk about the next time you saw either one of those persons.
I've never seen him
Okay.
since that incident happened.
Let me ask you that. This person that you're now calling Wendy here today, when is from that day, the day that you were thrown out of your car, when is the next time you saw her?
Right now on the picture on TV, it's the first time that I've seen her, and I see her on TV this minute.
Okay, so the next time you saw her was today at this hearing on the computer
That is
screen. Is that right?
correct. That is
Okay.
correct.
Did you ever at any point see her or identify her to law enforcement prior to today?
I have not seen her. I have not seen her. I have not seen a picture of her. I haven't anything of her. There's never been a contact
Okay.
since that
So-
incident.
And as you sit here today, this person you've identified as Wendy is sitting in jail orange, isn't she?
Yes,
Okay, and she's in a screen identified as Butler County Jail, correct?
I didn't know where she was at. Have never been told.
Well, is
So
the
I can't-
screen, ma'am, is the screen that she is on the computer screen, does it say Butler County Jail on it?
Yes, it does.
Okay. Now, the other person, this thin, petite person, since the day this happened, have you seen her at
Objection,
all?
Your Honor, relevance to this
No.
particular prelim.
Mr. Watts?
Wait, Ms. Zilke.
I think it goes to the reliability of the identifications in this case.
Wait,
May I
Ms.
ask a
Zilke.
question, Mr. Watts?
Go ahead.
Since the day this incident happened, have you seen the other person involved, this thin, petite girl?
No, I have not.
Okay. I want to make sure I'm clear. At no point did law enforcement approach you with any photographs of any people that ask you to identify anyone? Is that correct?
That is correct. Never have they done that. Ever.
They never brought a person by your house or your residence to see if you could identify them?
No, they did not.
And you've used the term Wendy here today to describe this person, okay? And I may have asked you this earlier. Where did you get that name, Wendy?
Objection, Your Honor, asked and answered.
Objection sustained.
Okay, I see that. Okay. Your Honor, I don't think I have any other questions today. Thank you.
Doris, is there any reason why we can't release Beverly Zielke from the meeting at this time?
No, Your Honor, thank you.
All right. Ms. Zielke,
Yes,
you can stay with this meeting if you want to, or you can leave it. But if you stay, I need you to go ahead and put yourself back on mute, okay?
I have to put it on mute.
Yes.
Wendy,
Yeah.
come here, honey.
Okay.
That, I don't, might have to call my,
That's fine. Very good. Very good. We'll move on. Ms. Norris, do you have additional witnesses to call?
Your Honor, just briefly, Detective Chandler.
Even Judge Ricky chuckled at at Miss Silky calling her daughter. That was really cute.
Okay, if we can bring Detective Chandler in,
Detective Chandler.
I'll need him to join us with audio and video. All right, if you'd raise your right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, very well. Having sworn in the witness now, Ms. Norris, you may ask questions.
Please state your name and occupation for the record.
My name is Robbie Chandler. I'm a detective with the Butler County Sheriff's Office.
And how long have you been in law enforcement?
A little over 9 years.
And were you working your capacity as a detective on July 20th for the Sheriff's Department of this year?
Yes, I was.
And did you end up being the investigator affiant regarding Beverly Zielke case?
Yes, I was.
Okay. And do you see, I guess, how did you identify Miss Zielke?
She was on scene at the call, and we identified her by her name and date of birth.
Okay. And was that information that she provided to you?
Yes.
Okay. And the person that you had contact with regarding the incident, do you see her on the screen today?
Yes, I do.
And can you describe just briefly the person that you identified that day as Miss Zielke?
Older lady, white hair, wearing I can't see what color blouse she's wearing, but it looks like maybe light and dark blouse.
And Your Honor, I would ask that the officer has identified the victim, Beverly Zielke.
The record so reflects.
Thank you. And where did you have contact with her at?
It was off of Indianola and I believe 120th. The exact address I don't recall.
And is that within Butler County?
Yes.
Okay. And we previously heard from another individual. What part of the county were you in? Like the northeast, southeast, southwest?
Southwest part of the county, otherwise known as District 3.
Okay. And is that near the Augusta airport or closer to Rose Hill?
Near the Augusta airport.
Okay. And are there any hospitals or other medical facilities there in that area?
No.
Okay. And was this a gravel road?
Yes, it was an unpaved gravel road.
Okay. And were you able to find the scene where the incident happened? You were actually at somebody's house, but that's not where the incident happened, correct?
Correct. Yes, I was able to find the scene where it happened on 120th, just west of the intersection of Southwest Indianola.
Approximately how far from where you had contact with Miss Zielke was the place of the incident?
Maybe 300 yards, 200 yards. It wasn't very far.
And less than a mile?
Yes.
Okay. And were you able to identify Miss Zilke's car?
Yes, the 2024 Nissan.
Okay, and were you able to locate Miss Zilke's car at some point?
Yeah, on flock camera.
Okay.
Um,
And approximately how much is that vehicle worth?
I have to look at my notes.
And I don't need the specific
I
dollar.
don't know. I don't know if I have an exact value of it. I think it's more than $30,000.
Okay, more than $30,000.
Yes.
Okay, thank you. That'll be sufficient for our purposes at the moment. Now, you were able to locate Miss Zilke's car, this Nissan,
Yes.
and were you able to, I guess, were you there when it was initially stopped, and who did that?
Yeah. I was the on-call detective. I had gone home after the initial investigation, and I got called back out after midnight. WPD, Wichita Police Department, had made the stop and located the vehicle.
Okay, and did you then have information regarding who was driving this said vehicle?
Yes.
Who was that?
Objection, Your Honor, calls for
Wendy
hearsay.
Scott.
Your Honor, calls for
Ms. Norris?
hearsay.
Regarding the hearsay objection?
Your Honor, the officer may have gotten information from WPD, but had to identify and actually locate any persons that they were referring to. So, Your Honor, it does not go to the truth of the matter asserted. It goes to basically the process of his investigation.
With that limitation, Ms. Norris, the court will overrule the objection. You may continue.
And Mr. Detective Chandler?
Yes. Wichita Police Department had located the vehicle off, I believe, Shady Brook Lane, and found Miss Wendy Scott as the driver. And I believe she had one other passenger, Mr. Alan Berry.
And were you able to talk to Miss Scott?
Yes.
And the person, where did you talk to Miss Scott at?
At the Wesley Medical Center.
Okay.
on Filson.
Had there been an accident regarding the Nissan?
No.
Okay. So you ended up speaking to Miss Scott at Wesley Medical Center.
Correct.
And did she identify herself to you?
Yes.
And what did she identify herself, or how did she identify herself?
She identified herself as Wendy Scott. Trying to think how if you want to say it, but she just identified herself with name and date of birth.
Okay. And were you able to confirm that?
Yes.
And do you see the person that identified themselves as Wendy Scott on the screen today?
I do.
And please describe her for the court.
Black female. She's wearing an orange jumpsuit.
Your Honor, ask that the record reflect that the officer has identified the defendant, Wendy Scott.
Record again, so reflects.
And did Miss Scott talk to you about this case?
Yes, she did.
And did she do it under Miranda?
Yes, she did.
But even not under Miranda, did she do it voluntarily?
Yes.
And did she make admissions regarding what happened with Miss Zilke?
Yes.
So did she admit being in Miss Zilke's vehicle?
Objection, Your Honor, leading.
Objection is sustained. Let him tell the story here, Ms. Norris.
Just briefly, Detective, what did she tell you involving Miss Zilke?
She told us, excuse me, told me, one second, I like it. She said she started off by saying it was all of her friend's fault. Said her friend was identified as a Tylisa Colvin. Said that it was Miss Colvin's idea to give Zelke a ride into the county under disguise of being sick and taking her to the hospital. Once they got her out into the county, they would take her vehicle from her and her belongings.
And did you rely upon that name that she gave you when she was basically her, I guess, her co-defendant's name?
Yes, I did. And she said that those belongings were still of Miss Zelke's that they took were still in her possession. And with that information, I applied for a search warrant and executed a search warrant on Miss Colvin's apartment in Wichita.
And did you find that Miss Colvin was or was not her co-defendant?
She was not. She had given me a statement that she had just gotten a ride from Miss Scott that night when I believe something happened to her car and she was chased by a dog. And this information was confirmed by Miss Colvin's employer.
Okay, so were you eventually able to identify the defendant, Miss Scott's co-defendant?
Yes,
And what's her name?
Elizabeth Rosa Rogers.
Okay.
What did Miss Colden do that she deserved for the defendant to try to frame her as the co-defendant in order to protect Miss Rogers? Because it sounds like Miss Colden wasn't involved at all. And Wendy tried putting the blame on her. What?
And so based on your conversation, your interview with Miss Scott, the defendant, she basically admits that she was present and took Miss Zilke's car.
She said it was, I believe it was, may I refer to my notes real quick?
Sure.
Miss Scott admitted to the ordeal up until knowing how she came about having the car.
Say that. You kind of cut out a little bit. Miss Scott said what?
Miss Scott admitted to being with their co-defendant, Miss Rogers, up until the point where they were at Miss Zelke's apartment. And the next thing she remembers is that she's in Miss Zelke's car driving it around.
That's convenient.
Okay. So she, okay. And was that when she's getting pulled over by Wichita PD?
Correct.
Okay. And is that the same day or basically the same 24-hour period?
Yes.
Thank you, Detective Chandler. I don't think I have any further questions, but Mr. Watts may have some follow-up.
Okay.
Mr. Watts?
Thank you, Your Honor. Detective, I want to follow up on that last part.
Yes.
You spoke with Ms. Scott in a hospital, correct?
Correct.
Okay. Do you know why she was there?
No, I was never told why exactly she was there until later on. I was given that she had PCP in her urine.
Okay. She's there apparently for some sort of a drug treatment or something like that. Is that fair?
Yeah. Yes.
Okay.
Who messes with PCP anymore? It never goes well.
When was that? Was that the same day, the next day? When exactly was that?
That would have been when the police took her there. I think it was after midnight, so it would have been the 21st of July.
Okay. And this incident took place on the afternoon of the 20th, correct?
Correct.
Okay. So the next day,
Correct.
okay. I guess here's what I'm trying to figure out. How did you come to go to Ms. Scott there in the hospital and inquire about this case?
She was taken there by Wichita Police Department after they stopped her vehicle in Shady Brook Lane and took her into custody.
Okay. And by her vehicle, are we talking about Ms. Zilke's vehicle?
Correct.
Okay. So WDP stopped the car, and she ended up going to the hospital.
Correct.
Okay. I presume, to your knowledge, then she's in the car, correct?
Yes.
All right. Now, if I understood your testimony at first, well, let me back up a little bit. What's her demeanor and condition as you're talking to her here in the hospital?
She would get loud. She was asleep. We had to wake her up a time or two. And then she would just start right back up where she led off at.
Okay.
She was aware. She knew her name was. She knew where she was. She asked for us. She wanted to talk to us, law enforcement.
Well, the reason I asked that is I'm looking at your affidavit,
Yes.
and the affidavit tells that basically you learned that she was ready to talk, right?
Correct.
But when you got there, she was asleep and had to be woken up.
Correct.
Okay. As you're talking to her, did she fall back asleep again?
At one point during the conversation, yes.
Now, she spoke during this conversation with you in the hospital about essentially the plan to get control of this car. Is that correct?
Correct.
Okay. And that this other person that she identified as Colvin would essentially do the ruse to get her in the car and try to take her to the hospital.
Correct.
Okay. But you testified a moment ago that the next thing she knew, as she put it, she was in the car and being picked up by WPD. Is that right?
Correct.
She didn't provide any information of what happened in between?
Yes, she told us about going up into Miss Zelke's apartment. That she was with Miss Colvin, and I think Miss Colvin at that point had stomach aches, and that was how they got her to go take her to the hospital, which was a way to get her out of the apartment. But Miss Scott never said anything about what happened after the apartment.
Okay.
At that time with Miss Colvin.
I think that's all I have at this time. Thank you.
All right. Any reason why Officer Chandler can't be released from the meeting at this time, Ms. Norris?
No, Your Honor. And
Yeah.
actually, Your Honor, no further witnesses, but I do have some amendments to make on the record.
All right. Does the defense intend to present evidence at this hearing?
Not at this hearing, Your Honor. Thank you.
Very well. Your amendments that you're requesting, Ms. Norris?
Your Honor, state would be moving to amend count 1 to aggravated kidnapping, which is a level 1 person felony based on injury. And I would be moving to amend count 5 from misdemeanor theft to felony theft, a level 7 non-person felony based on the value of the Nissan plus the other items already listed in that count. And nothing further, Your Honor.
Any objection to the amendments, Mr. Watts?
No, Your Honor.
All right. Ms. Norris, your theory regarding the amendment on count 1, obviously, the bare bones pleading that you filed in this case doesn't help the court sort out exactly what your theory is. So now that you've upgraded from kidnapping to aggravated kidnapping, what is the evidence before this court that would suggest that the court should bind over and find probable cause as to either kidnapping or especially aggravated kidnapping?
Your Honor, aggravated kidnapping, taking or confining any person accomplished by force, threat, or deception. Deception because they basically got her to take them to, well, allegedly to take them to a hospital. And obviously they ended up being nowhere near a hospital. And then the aggravated portion of it would be when bodily harm is inflicted upon the person kidnapped. And the Ms. Zilke clearly stated she had bodily harm.
All right, and the evidence supporting a holding?
Your Honor, based on the kidnapping,
Yes.
but basically she was in a vehicle and they basically, the theory would be that they took her and that she was basically confined in a vehicle. And it was all under deception, a ruse. Deception to get her to basically get away from her apartment so they could basically steal her car from her, but they had to isolate her out in the country. So basically, even though she's the one that's driving, they're the only reason she's going is because of them. So that would be state's theory.
All right, taking her by deception with the intent to hold her to facilitate the commission of the later felony theft.
And and the aggravated robbery.
Very well. The court will allow the amendment to count 1 to reflect a charge of aggravated kidnapping as requested, as well as the amendment to count 5, upgrading from misdemeanor theft to felony theft. Court finding that there is evidence in the record to support such amendment. Court further finds that based on the evidence presented, that the felony crime of aggravated kidnapping has been committed and that the defendant, Wendy Scott, committed it. Regarding count 2, the court does find that there's probable cause that the crime of mistreatment of a dependent elder person, a level 5 person felony, has been committed and that the defendant, Wendy Scott, committed it. Regarding count 3, the court does find that there's probable cause that the felony crime of criminal threat has been committed and that the defendant, Wendy Scott, committed it. Regarding count 4, the court does find that there's probable cause that the felony crime of aggravated robbery has been committed and that the defendant, Wendy Scott, committed it. Regarding count 5, the court does find that there's probable cause from this hearing that the crime of felony theft has been committed and that the defendant, Wendy Scott, committed it. And regarding count 6, the court does find probable cause that the felony crime of interference with law enforcement, a level 9 non-person felony, has been committed and that the defendant, Wendy Scott, has committed it. Therefore, the court binds the defendant over on all 6 counts as amended following a presentation of evidence. We will proceed to arraignment at this time. Mr. Watts, does your client desire the charging document to be read to her?
Your Honor, we discussed the charges. Would waive formal reading of same and are not guilty at this time. Ask the case be set for appropriate pretrial and jury trial settings.
Very well. Thank you, Mr. Watts. The court will set this case for both jury trial and pretrial conference settings.
And Your Honor, the defendant has her hand up. I'm not sure if she needs to address the court or her counsel.
Okay, well, we're going to do our scheduling first, then I'll address her. Mandy, if you could suggest our February trial date for Butler.
My daughter is going to die. Oh, she's going to die. I just want to see my baby. Can I please
Mandy?
talk? Judge?
Just a moment, Ms. Scott. Let me finish my scheduling here.
Okay, it'll be February 25th for the jury trial date.
And can you suggest a pretrial conference date the week before?
Okay. Friday. I'm sorry, I didn't look at the date. Friday, February 21st at 9 or 10 a.m.
We'll make this 9 o'clock a.m. Court will establish pretrial conference as the next scheduled setting at this time for February 21, 2025, 9 o'clock a.m. That will be conducted by Zoom. The court will establish jury trial date currently set to begin 9 o'clock a.m. on February 25, 2025. That will be an in-person proceeding, Courtroom B, Butler County Judicial Center, El Dorado, Kansas for all stages if it goes. So February 21, 9 o'clock for pretrial conference by Zoom. Jury trial set to begin February 25, 2025. All right. Ms. Scott, I'll address you now.
Yes, sir. All I'm asking, my baby is dying. That's it. I wrote a letter to the courts and to my lawyer letting them know that she's dying. All I'm asking is for a fella to speak with my baby. That's it. She might not make it to February. She might not make it 8 years from now, but my baby is dying. That's all I'm asking. She got Thursday cancer, sir. That's all I'm asking. Can I just see her?
Okay, who is your baby?
My daughter, Kanai Scott Collins. I wrote the court's and put her room number, what hospital she's in, and everything. I've been writing, asking. I just want to see my daughter. She got brain cancer. That's it. I've been begging and pleading. She's in Wesley. She's in Children's Mercy. She's in the PIC unit. You can call and verify it. I've been asking here just to call and talk to her at the nursing station. I'm not even getting that. I don't even have money on my books because they won't let me work. I just want to see my baby. That's it. That's it. Just see my daughter. I'm asking you, Judge, whatever you want me to do. I'm not running none of that. You can put a monitor and everything. I just want to see my baby. She might not be there. She might not be able to see me 2 days from now. I'm just asking. Please, just hear me out.
Children's Mercy, where? Where's that at?
She's on Wesley Main, the Children's Mercy. She's on the PIC unit floor. She's in the pediatric ICU. You can verify it.
Okay, so I'm having difficulty because of your emotional speaking here. But I think you're talking about Wesley Medical Center in Wichita?
Yes, sir. She's on the PIC unit. She's in Children's Mercy. Dr. Shaw is her doctor.
Okay.
My baby is suffering. All I want to do is see her. That's it. Whatever else y'all want to do. If she died in my arms, when she see me, then that's it. That's all I want to see is my baby. That's it, sir.
Does the state take a position on the request?
Please, please.
Your Honor, I don't, this is the first I've heard of it. I suppose without any verification, I would have concerns about that. I know her bond is currently set at 100,000 with GPS required, and that she's only to be in Butler or Sedgwick County. Obviously, Your Honor, I have concerns about her being out. She's got a lot of history out of the state of Iowa. She is presumptive. She's at least a C, maybe a B. It kind of depends on how some of her previous convictions shake out, but she's definitely a C. And based on these charges, she's presumptive prison.
I
So
swear, I just want to
certainly
see
have
my baby.
concerns.
I just want to see. I wrote the courts and everything weeks ago. I just want to see her.
Right.
That's it.
The court will first of all make an observation. It seems to be kind of a disturbing tendency out of the women's cell at the Butler County Jail for them to write letters to this court asking for all kinds of things. Ms. Scott, apparently you are one of those that's bought into that. You're not supposed to be even trying to communicate in writing behind the prosecutor's back the way you've been doing.
I did. They told when I went to, I asked the person at the jail that's above in the jail.
And so when you attempt to communicate with the court, do you also send it to the prosecutor so that she knows what you're doing?
Okay.
I would suspect you don't.
I did, and they told me to write straight to the judge and to my lawyer.
All right. Well, all right. Regardless of how any attempted communication may have been sent to my office, Ms. Scott, the court is considering here that you are facing presumptive prison felonies. You've now been bound over on those.
I promise you, I'm not.
And I don't mean to be heartless or cruel. I don't know if what you're telling the court is legitimate or not.
My lawyer, I even gave my lawyer phone numbers and everything to verify. I gave him everything to verify.
You're a poor risk for a furlough, Ms. Scott. I don't want to be in a situation where you're released from the jail and we have to recapture you to get you back.
You won't.
There are implications to criminal behavior, and you've been bound over on these felonies. The court has found probable cause that you committed these crimes. You haven't been convicted yet. The court clearly recognizes that. But again, there are implications to criminal behavior, Ms. Scott, and
Oh, I'm
unfortunately,
so sorry.
access to your family can be one of them. The
And
court is not
I'm
going to
the only
modify your
family
bond in any way,
here.
and the court is not going to grant your furlough request.
Can
So
I
the
please get
request is
rid of my
denied.
bond?
The court has already considered and denied any bond relief. All right.
So if my daughter dies, I can't see her then either. I just want to see her. That's it.
All
That's
right.
all I was
Mr.
asking.
Watts, anything further from your perspective at this time?
Not at this time, Your Honor.
You pushed an 86-year-old, you pulled an 86-year-old woman out of her vehicle and dumped her on a gravel road and drove off without a care in the world of whether or not she would pass away or her family would be without her. I'm sorry, but true or not regarding the situation of your daughter, you made choices that would take you out of your daughter's life. You weren't concerned about your daughter or seeing her while you were joyriding around in Miss Beverly's car. No.
Thank you.
From the state's perspective, Ms. Norris?
Miss Norris, please.
No, Your Honor. Thank you.
All right. The Scott matter will currently be in recess. This meeting may be ended for all at this time. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Wendy Scott. It's case number 2024 CR 346. James Watts appears as defense counsel. Wendy Scott appears from the Butler County Detention Facility's Zoom location. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for pretrial conference. Court noting that the matter last came before the court on October the 30th. An evidentiary preliminary hearing was held. At that time, the state had moved to amend count 1 to aggravated kidnapping and count 5 to felony theft. Those requests were granted. The court found probable cause on all 6 charges. At arraignment, the defendant waived reading, entered a not guilty plea. Pretrial conference was set for today, with jury trial set to begin on February 25 at 9 o'clock. Requests for furlough and bond modification were denied by the court. With that recap, Mr. Watts, what is the current status of the case and what announcement is made?
Your Honor, the state had made an offer in this case, an offer that's consecutive, or not consecutive, it's the same as the offer made the co-defendant, Ms. Rogers. My client, I understand, wishes to enter a no contest plea accepting that offer. That offer is to count 1 as originally charged, which is kidnapping as a level 3 offense, as well as count 3 and count 4, all concurrent mid-box. We do reserve the right to seek departure. I assume the state will oppose that departure. I would expect the state would oppose that departure. I think that's all I have, Your Honor. Thank you.
All right. I want to make sure that I'm aware of what charges your client's conceivably going to be pleading to. Count 1 then would be kidnapping, a level 3 person felony. Count 3, criminal threat, a level 9 person felony. And count 4, aggravated robbery, a level 3 person felony. Is that your client's intentions?
Yes, sir.
All right. Ms. Norris, has Mr. Watts announced consistently with your understanding as to how the Scott case would be handled?
Yes, Your Honor.
All right. Ms. Scott, I've got a number of questions I need to ask you regarding the taking of a felony plea. If there is any question asked of you that you do not fully understand, I would give you the opportunity to confer privately again with your lawyer at any point if you need to get further advice along the way. Okay?
Yes, sir.
Just let the court know if you need that time.
Yes, sir.
I'm going to start off by having you state your full legal name for the record.
Wendy Sincere Scott.
How old are you right now?
I'm 40 years old,
What's the highest level of formal education that you've attained?
11th grade.
Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
No, sir.
Have you ever been adjudged to be mentally ill?
I have depression, anxiety, depression. I take mental health meds for.
Are you getting those mental health medications in the jail?
Yes, sir.
Do they help you and improve your mental state?
Yes, sir.
Okay. All right. Do you believe you have a full understanding of what's going on here in court?
Yes, sir.
All right. And you can tell the court then that you're not under the influence of alcohol or any drug?
I'm not under the influence of anything.
All right. Now, did you receive a copy of the original charges in this case?
I think so. From the jail, I think that they gave me just a paper. It is like it was, when I first came, I still got that paper.
Okay. Do you understand the nature of the charge of kidnapping? That would be in amended count 1?
Yes, sir. Yes, sir.
Do you understand the nature of the charge of criminal threat in count 3?
Yes, my attorney explained it all.
Okay. As he should.
Yes,
And do you understand the nature of the charge in count 4, aggravated robbery?
yes, sir.
All right. You understand that when you enter pleas of no contest, you are not necessarily admitting that you did these things, but you're also not contesting that you be convicted of these offenses just the same. Do you understand that? Ms. Scott?
Yes, sir.
All right.
I didn't know if you heard me. I'm sorry.
I did not. So I would appreciate if you'd speak up when you answer. I just want to make sure all participants can hear your responses to the court's questions.
Yes, sir.
All right. You further understand that when you enter pleas of no contest, you'd be giving up any legal defenses that you might have had to those charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your attorney, Mr. Watts, and present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
Understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand, Ms. Scott, that you have a right to appeal a guilty verdict if you have a trial?
Yes, sir.
You further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas.
Yes, sir.
Are you aware of the possible sentence that could be imposed as a result of these pleas that you're attempting to make?
Yes, sir.
Let's go over those. Level 3 felonies in Kansas would be on the non-drug offense grid. In the most favorable criminal history category of I, you could receive as little as a 55-month prison sentence. In the worst criminal history category of A, you could receive up to a 247-month sentence. So the sentencing range for level 3 would be 55 to 247 months in prison.
Yes, sir.
A level 9 felony, such as the criminal threat, in the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. In the worst criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range for a level 9 felony is 5 to 17 months in prison. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for a level 9 offense.
Yes.
You also understand that you could receive up to a $300,000 fine on a level 3 offense.
Yes, sir.
Ms. Scott, I need to point out to you that at level 3 on the non-drug offense grid, any level 3 crime would be presumptive prison under Kansas law. Do you understand that?
Yes, sir.
Do you understand the difference between consecutive and concurrent sentences?
Yes.
Let's go over that. Concurrent sentences mean that they run all at the same time. When you're serving one, you'd also be serving another. Obviously, that would result in a much shorter overall sentence. Consecutive sentences are boxcard, back to back. You have to serve all of one before you even start serving the next, which would obviously result in a much longer prison sentence. Do you understand, Ms. Scott, that regardless of any plea agreements that's been reached, it's up to the court to determine whether your counts run concurrently or consecutively?
Sir.
Ms. Scott, I also need to point out that the Kansas Sentencing Guidelines Act has what we call special rules. If any special rule applications would apply to you in your case, do you understand that it could affect your sentence or affect your ability to be put on probation? Do you understand this?
Yes.
All right.
I have a question. You said special rule?
Yes.
What did that, like a special rules, like if I haven't heard of a special rule on my case?
I don't know that one would apply, Ms. Scott. I
Okay.
just need to make you aware that the Kansas Sentencing Guidelines Act is just a big book of sentencing rules and laws. And among those, there are some special rules that sometimes come into play. Generally speaking, your attorney will be aware of special rules that might apply to your case. And he would have discussed those with you.
Okay. No, he
If
didn't.
he
And
didn't,
Your Honor,
okay, go ahead.
I'm sorry, Your Honor, I would note, I'm not aware of any special rule particularly that's likely to apply here. As far as I know, she's not on probation or parole at this time or anything, so I don't know that there's one that really applies here.
Ms. Scott, are you satisfied?
Yes, sir.
All right, then let's go further.
Mhm.
You also understand that in addition to any fines that might be imposed, you could be assessed and be required to pay court costs, certain fees, and restitution to victims, if any are owed, as part of your sentencing orders.
Yes, sir.
You also realize as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, sir.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Some of those circumstances might actually exist here. Do you understand that?
Yes, sir.
All right. Now, Ms. Scott, do you feel like that you've had an ample opportunity to discuss legal matters and sentencing options fully with your attorney, Mr. Watts, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go further?
No.
All right. Are you satisfied with the services and advice given to you by your attorney?
I am.
Now, Ms. Scott, this no contest plea set that you're attempting to make, has this been based on any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No.
Ms. Scott, is there anything else that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
No.
All right. Do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes. So I have a question. So when we get plea agreements, we don't get that? We don't
It
get.
doesn't bind the judge.
Oh,
It
okay.
binds the prosecuting attorney, perhaps might require her to make certain recommendations or remain silent on certain things, but it doesn't bind the court. That's what I want to make sure you understand.
Okay, yes.
All right. So, Ms. Scott, how do you formally plead to the charge in amended count 1, kidnapping, a level 3 person felony,
No contents.
and in count 3, criminal threat, a level 9 person felony?
No contents.
And account 4, aggravated robbery, a level 3 person felony.
No contents.
All right. I'm going to ask the state for a concise factual basis as to each charge.
Your Honor, on July 20th, 2024, the defendant did take Ms. Zilke by way of her vehicle from her apartment in Wichita into Butler County, where she did threaten to cause her harm and did forcibly remove her from her vehicle, the gray 2024 Nissan Altima, and did take that and her purse and a dog in the process, and left her on the side of the road, and that was near Southwest 120th Street, Augusta, Butler County, Kansas.
Okay. The taking originally was accomplished by what means?
The taking of Ms. Zilke or the taking of the vehicle?
The take.
They asked for a ride, and initially Miss Silky thought they were going to, was basically taking them to a hospital, and they kept giving her basically false directions, which led them into Butler County, and they kept giving her further directions that got them even deeper into Butler County, and she basically then was concerned. So basically they deceived her in where they were going. Then she questioned them, and then the threats and the taking of the vehicle and the other part of it occurred.
All right. So the taking of the person of Ms. Zilke was done by deception.
Yes, Your Honor.
All right. Now, the specific criminal threat, I understand that you mentioned threats, but what oral statements were made that could be construed as a threat under these circumstances?
Your Honor, they did have I believe they did have a firearm, and they did threaten to shoot her or do harm to her with the gun if she didn't if she didn't give them the vehicle or whatever else they wanted.
All right. Thank you. And I see that same language is included in count 4 on the aggravated robbery charge. That they took the motor vehicle by force or threat of bodily harm. What was the bodily harm inflicted on Beverly Zilke?
Your Honor, she did have some scrapes and some bruises from where she was basically pulled from the vehicle and ended up in the roadway.
Okay. So they literally dragged her out of the car and
Yes, Your Honor.
put her on the ground?
Yes, Your Honor.
Oh, all right. Very well. All right. So, Ms. Scott, at this time, are you making pleas of no contest freely, knowingly, and voluntarily, and accepting conviction for, in count 1, kidnapping, a level 3 person felony, count 4, aggravated robbery, a level 3 person felony, and count 3, criminal threat, a level 9 person felony?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court should not accept this defendant's plea?
No legal reason, Your Honor. Thank you.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
Wendy Scott, are you aware of a legal reason or any other good reason why the court shouldn't accept your pleas of no contest this morning?
No, sir.
Court will accept the no contest pleas made by Wendy Scott and finds that those pleas are made voluntarily. She has an understanding of the nature of her charges and the consequences of her plea, and a factual basis for the pleas does exist. The court finds the defendant guilty, and the judges are therefore convicted of the crimes of kidnapping, a level 3 person felony in count 1, criminal threat, a severity 9 person felony in count 3, and aggravated robbery, a severity level 3 person felony in count 4. All other charges of the charging document are dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Ms. Scott's criminal history, and the court will set an appropriate date for sentencing. Ms. Scott, if I had my preference, we'd go ahead with sentencing today, but we really can't do that. There has to be a research of your prior criminal history. That takes time. We generally allow about 2 months for completion of that report. If you're asked to do any assessments of any kind, I will expect you to fully cooperate with those assessments, but I will set a sentencing date about 2 months out, and then you'll be sentenced at that time. Counsel, that will put us mid to late April. One date I was looking at, Mr. Watts, was Friday, April the 18th at 1:15 p.m.
Yes, sir, I can do that.
All right. Ms. Norris, I trust that'll work for you.
Yes, Your Honor.
Sentencing in the Wendy Scott case will be Friday, April 18th at 1:15 p.m. Would you expect that there would be a victim statement?
Yes, Your Honor.
All right. I think we can still go ahead and conduct this proceeding by Zoom. I know Ms. Scott is in custody. And I do recall that Ms. Zielke is elderly. I believe Zoom might accommodate her better. Friday, April 18, 1:15 p.m. will be the Wendy Scott sentencing. All right. I think my assistant will go ahead and notify court services at the conclusion of this hearing. I know Ms. Scott's not in a position to meet with them or call them at this time. And I think she can give them the basic information regarding the need for a pre-sentence investigation and report. So thank you for doing that, Mandy. Friday, April 18, 1:15 p.m. for sentencing in the Wendy Scott case. All right, Ms. Norris, is there anything else that we need to address currently regarding Wendy Scott?
No, Your Honor. Thank you.
Mr. Watts, anything further at this time?
No, Your Honor, thank you.
Very well. Ms. Scott, you have any questions about what we've done here today?
No, sir.
Very well. Then if there's nothing further, the Wendy Scott matter will currently be in recess. I'm sorry.
Asking my lawyer, can he come and see me too?
I can.
Thank you.
All right. Thank you. And if there's nothing further, the Scott matter's in recess. This meeting may be in. Wendy Sincere Scott, case number 2024 CR 346. Amber Norris appears for the state of Kansas and the Butler County Attorney's Office. James Watts appears as defense counsel. The defendant, Wendy Scott, appears from the detention center's Zoom location. This matter comes before the court at this time for sentencing. Court's docket notes indicate that Ms. Scott appeared before this court on February the 21st of 2025. At that time, the defendant pled no contest and accepted conviction for count 1, apparently as amended, kidnapping, a level 3 person felony, count 3, criminal threat, a level 9 person felony, and count 4, aggravated robbery, a level 3 person felony. A pre-sentence report was ordered and sentencing set for today. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in this report?
No, Your Honor.
Is there any objection by the defense, Mr. Watts?
I've reviewed it with my client, Your Honor. We believe it is correct. Have no objection.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score B, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Scott case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, Your Honor.
Ms. Scott, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
We'll proceed further then. Regarding sentencing related motions, this court is aware there has been a motion entitled Motion for Durational Departure submitted by the defense. The court has a copy of that before it. Mr. Watts, you may proceed further in regards to this motion.
Thank you, Your Honor. Your Honor, I'm not going to go through the entirety of the motion. The written motion is there, and I'm sure the court has read it thoroughly. I want to speak only to basically a couple of parts of it. As I noted in the motion, this is a case that my client, and as I've noted right from the beginning, my client knows full well this is not what a court wants to hear at a time of sentencing. I've heard Your Honor in other cases specifically speak to this very issue, so we knew what we're kind of getting into when we say it. But my client has argued from day one and alleged from day one she did not commit this offense. That continues to be her position. And that continues to be her position despite the plea entered in this case.
That's not correct. Because from day one was the day that she was talking to the officers, and she admitted being into the house. She admitted driving the car. She was found in the car. It was kind of hard not to admit that part. So no, Mr. Watts, she changed that after day one.
And I will focus only on a couple of things as part of that. I had occasion to have a phone call. The most important part of this is Sierra White. Sierra White was a person over in Wichita who I spoke with on the phone at one point. Ms. White told me at one point during that phone call that a car came by, the car that was stolen in this case, and picked Ms. Scott up, that Ms. Scott had been with Ms. White during that time. However, I know full well that me relating a phone call to the court is not admissible in court. There's no way that by itself is going to be sufficient. I spent 5 months with a private investigator attempting to locate Ms. White. And it's just very clear that over the course of that 5 months, Ms. White did not want to be located. The private investigator had occasion to go to her house, speak to, if I remember correctly, a daughter, but Ms. White was never there, was never where she was said she was going to be. My investigator spent, I don't know exactly how many times, but 5 months of attempts to contact Ms. White. And as I made it clear in the motion, Ms. White apparently didn't want to be contacted for a couple of reasons. One, she had apparently had a warrant out. I, of course, as in my circumstances, don't care at all about the warrant. That's not my concern. But the other is in the world that Ms. White lives in, and to a certain extent, the world that Ms. Scott lives in, I'm certain, is not the same world I live in, and perhaps you live in, Your Honor. In Ms. White's world, police are not to be trusted. Authorities are not to be cooperated with. That is not assistance, that's betrayal. So Ms. White was unable or unwilling, maybe a better way to put it, unwilling to come forward.
Miss White is this imaginary person that has never existed in any of the other hearings. She called Mr. Watts's office and gave an alibi for Wendy, that Wendy, she was chilling with Ms. White, and then this car pulls up and she got in the car. Like, oh, she couldn't have been part of the assault. She was with me. But this has never been mentioned before because it didn't happen.
Without that confirmed witness, which would have been an alibi witness had she been able to come forward, had she been willing, maybe put it more accurately, had she been willing to come forward, this case was simply not viable to try. I discussed that with Ms. Scott, and she made a determination that she did not want to continue to find Ms. White, to continue to pursue a defense, but rather would simply resolve this case by plea. In doing so, she saved the state and the court significant time. She gave up not only the ability to defend this case in court, but in any realistic sense, the ability to appeal it as well, as I discussed with Ms. White. So, as I said, I'm not going to go completely through the motion and not going to get into the details, but I thought that needed to be spoke to. And as I started from the beginning, my client and I understand that is not what courts want to hear at time of sentencing. It is, however, the reality, Ms. Scott's position in this case. Frankly, I don't know, had we been able to secure Ms. White's testimony, how this case would have gone. That is speculation. Had her testimony been consistent with what she at one point spoke to me on the phone, there may have been an alibi witness and a viable alibi witness. But given the certain reality, that was not possible. One of the bases for a departure is that there was a valid and defensible witness, valid and viable defense, even if a jury did not accept it. Now, this is not that case where a jury did not accept a defense. This is a case where the defendant was unable to put on that defense because the witness necessary to that defense was unwilling to come forward. For those reasons, and again, I'm not going to get into the rest of the motion at this point, we would ask the court to consider a durational departure in this matter, if not a dispositional one. I'm not asking for a dispositional departure, but a durational departure in this matter. Thank you, Your Honor.
Well, it's a question from the court. Even if this Sierra White could be located and testified in the manner in which you described, that she saw Wendy Scott being picked up in the stolen vehicle, that doesn't mean necessarily that Ms. Scott wasn't involved in the original taking of that vehicle, because this obviously would have been much later than the actual taking. True?
No, Your Honor. It is if what Ms. Scott also told me that she had been with Ms. Scott that day and had been with Ms. Scott all that day. It was picked up later that day. If that is in fact the case. Now, again, I have no way to know if that's the case because she was unwilling to come forward and be interviewed and take part in this case. We believe this would have been, again, were we able to interview her and were she able to come forward? This may have been an alibi witness.
A durational departure is where the defense or the prosecution requests that the court doesn't follow the guidelines, even if there's a state minimum and maximum in the penalty. So they're allowed to request it. The judge does not have to grant it.
Can never know that with any certainty, of course, because she was unwilling to come forward.
Very well. Anything further on the departure motion, Mr. Watts?
No, Your Honor. The motion speaks for itself as to the remainder.
All right. Does the state wish to make argument in regards to the departure motion currently before the court? Ms. Norris.
Your Honor, keeping with the plea negotiations, the defendant was allowed to ask for departure, but there's no agreement, and nor was the state required to join necessarily. Your Honor, I find the bulk of the motion to not even really sure what to call it. It seems like maybe a work of fiction. There was no trial. This motion is the first I've heard of any alibi witness. None of that information was ever provided prior to this motion. And I really think it has zero bearing on the sentencing at this point. The defendant pled. And we negotiated the plea. Again, none of this was ever talked about. I feel, or the state's view of this, along with some other issues in this motion, is that, and defendant actually pled no contest, is that the defendant is unwilling or possibly incapable of taking responsibility for any of her own actions. So, like I said, she pled no contest. Now we're having a discussion about a possible alibi witness, which is irrelevant at this juncture. And I would also note let's see, I guess it's bullet point number 7, that she apparently has told her attorney that the reason, she's B is because of this flee and elude aggravated battery from 2020, which is 5 years ago, which is not that long ago, that she was a passenger, and that, basically, we don't even know how she ended up actually being charged. Well, that is completely inaccurate. She was the driver. She fled from law enforcement and she hit a police officer while she was fleeing. And that's directly from the official version in the PSI from Jackson County regarding the case and the conviction. So she's obviously, I assume that she told Mr. Watts that, she was the passenger and that she wasn't responsible for any of that. And so that's what he put in his motion. And again, back to not taking responsibility for her actions. So, I would ask that the court deny the request for any form of departure. We basically had spoken that we would recommend the mid-box presumptive sentence, and so we would be requesting that the court follow along with that plea negotiation, which is what we previously discussed. And does the court want recommendations at this point additional to that? And I also wanted to let the court know that the victim and a member of her family would like to address the court as part of sentencing today too.
Ms. Norris, the court will take up the state's formal recommendations a bit later in this proceeding.
Thank you, Your Honor.
All right. Having heard from both parties on the departure motion, at this time, the court will ask, does the victim or any member of the victim's family wish to address this court in relation to the Wendy Scott sentencing? Ms. Zielke, I see Zielke on the screen. You're muted currently. So if you'll turn on your audio and then you can make your statement to the court.
Can you hear us now?
I can hear you.
Okay.
Now what?
Ma'am, I'd first ask you to state your name.
Beverly Zielke.
Do you have a statement to make to the court?
I sure do. I'm the one they threw in the road and drove off in my car, my brand new car.
Okay.
That
All right,
still
ma'am.
had a paper tag on it. I never even had time to get a tag yet.
What do you want to say to Wendy? To Wendy.
Am I to speak to her
Yes.
now
You,
or what?
you can make whatever statement you feel is
I
appropriate.
cannot believe she did what she did. They played me for a fool. She was a neighbor. Her other friend was a neighbor, and she showed up at my house. I'd never met her, and she said, "Is she here yet?" And I said, "Here?" And she named the other girl, and I said, "No." She was coming to borrow a cookbook, and she said, "Can I come in and wait
You're
for?"
talking to Wendy.
Let's let Ms. Zielke
He
make
knows
her
what
own
happened.
statement, please.
Am I doing it wrong?
Just tell
I've
me
never
what
been
you
to
wanna tell
courts,
Wendy.
so I
You're
don't
doing
know.
fine, ma'am. I just don't want anyone else saying anything in the background or anything like that. I want you to make the statement, Ms. Zielke.
Well, I am.
Okay, go ahead.
And she took, and then she started rolling on the floor, and Wendy said, "Could you take us to the emergency room? She's having a bad time." And I said, "Well, yeah, I can take you. I can't go in because I'm babysitting my daughter's dog because she took a cruise and I'm babysitting." So we got in the car, and Wendy sat in the back seat. The other girl sat in the front seat. And they had me turn when you go to Andover. I thought we were going to Andover, and she said, no, turn. That's two roads before you get to Andover. And I drove on a country road, and I drove and drove and drove and drove and drove. And I said, where is this place you want to take her to be? Because she started, when she was in my house, she started rolling on the floor and saying her stomach was killing her. And when he said, oh, she needs to get to the emergency room, could you take us? And we drove and drove, and I finally says, how much further is this place? And she said, we're almost there. It's not too much further. And I drove and drove, and then I finally stopped the car, and I said, well, where is this place? We've been on the road a long time. And she held her purse up, and she said, see this purse? And I said, yes. And she said, I have a gun in it. I have used it before, and I'm sure not afraid to use it again. And then she yanked my car door open, and she started pulling my arm, and the other girl was in the front seat on the rider's side, and she was pushing me on my back trying to make it. I was hanging onto the steering wheel and trying to stay in the car, and they were yanking and pulling. And Wendy had long fingernails, and they were painted, and she kept pulling on my arm like this, and I had, her nails went through my skin from here clear down to my wrist. My whole arm was bleeding because her fingernails had went all through my skin, all around my arm, because she was trying to pull me out of the car. And she finally won. She pulled me out, and I had my daughter's dog in the car with me, and I didn't know if they threw me down in the dirt, and the dirt, my whole arm was black because it was bleeding with blood from top to bottom. And I was scared I was going to die because she threatened me with a gun, and it scared me to death. And after they threw me in the dirt on the country road, they took off, and they had my purse. They spent $1,000. They used a credit card. I think they bought gas. And I had to walk. I walked to one place, and they weren't home, and I walked another down in the next mile. And I finally came to a family that was home, and they called the police. And then the sheriff and the police and the fire station, the truck all came. They wanted to know if I wanted to go to the hospital, which I said no. But they cleaned my arm and disinfected it. The whole arm had her fingernails had gone through my whole entire arm. It was pure blood. And I was terrified. All I did was I was going to take her to a hospital because she said her stomach was hurting, and she's rolling on that mat floor back where the cookbook was in my house, the other girl. So I don't know. She never, ever, ever said she's sorry. She hasn't to this day. I went through a lot of hell with that, and I've never done anything in my entire life. I've never been in trouble with the police in any way in my entire life. I couldn't believe all of this was happening. All I was going to do was help them, because she was crying, and they asked me to take them to the emergency room. And I said, of course I'll take you to the emergency room. I don't know what else to say. You do want to have a question for me?
Ms. Zielke, the court would just ask you, is there anything else that you wanted to say to the court today about Wendy Scott's sentencing?
I think she's she's the one that took my car and drove it. Was the driver. She took my car and pulled me out into the dirt. And I didn't know if they took little Chloe or not because I had my daughter's dog in the car. I didn't find that for another week. I thought she was gone. I thought they had taken her, but they didn't.
Okay, so was the dog recovered then, Ms. Zielke?
Yes, finally, yes. And they had a month later, it was about 3 weeks later, and a farmer that lived he was at their house, and they had made when you on the dog pound thing, they had a left message that there was a dog, and we thought it sounded like Chloe, and so we went there, and it was Chloe.
3 weeks. They had to go 3 weeks before they got their dog back. I would lose my mind. All of the trauma that she went through as it was. And then the poor dog was left out in the elements for 3 weeks. Special place in hell, guys.
So we did get the dog back.
All right. Anything else? Ma'am?
I just I just can't believe that they did that. I just can't believe that she did that. They just threw me, and I'm 87 years old. I'm 87 years old. And they threw me in the dirt and threw me out of my car, out on a country road. I think she deserves to pay for something because I cannot believe she did. I can't believe anybody would do such a thing to anybody. I don't care their age. I can't believe they would do such a horrible thing. There was never anything bad to them. Everything they did was to hurt me. And I didn't realize that.
Ms. Zielke, thank you for your statement to the court. Just so we can eliminate background noise, could you go ahead and mute yourself again, ma'am?
Muted by
Mute.
that one. Okay, are we muted?
Is it done now?
Not yet. Okay, I think you are now. Thank you. All right. I'm going to perceive here that there's no other members of the victim's family who wishes to address the court.
I think maybe there is, Your Honor.
Okay, then if it's the person who's with Beverly Zielke, if they can go ahead and unmute themselves.
Unmute. Okay, now say that again, please.
Are you a member of
Yes, I'm her
Beverly's family?
niece. I am her niece.
Did you have any
And I've had
statement that you wish to make to the court?
Yes.
All right, first of all, state your name.
Wendy K. Dwyer.
All right. Ms. Blyer, what is your statement?
Dwyer, D-W-I-R-E.
Okay, thank you.
Okay. All right. First of all, my aunt clearly remembers Wendy Scott's face and clearly remembers Wendy Scott being in the apartment. This is my turn. The reason I felt it was important to speak to Wendy Sincere Scott is because I want Wendy to truly understand how horrific the crime she committed with her friend Elizabeth really was. Wendy, the reason I feel you need to hear this is because every Zoom court I watched, you never was concerned about my aunt. You were very concerned about yourself like you are today. My Aunt Bev is 87 years old, and you never once stated you were sorry, and you knew there was a good chance she was watching those on Zoom, but you never had any remorse about what you did to her, and that tells me a lot about you. You totally made a plan with your friend Elizabeth, who happened to live in the same building previously, to reach out to an elderly lady about a cookbook, and then your friend following through with y'all's plan to create a medical issue to get my Aunt Bev into her car with the two of you. This was totally planned with no remorse or feelings about it. Then you threatened her by telling her you had a gun and weren't afraid to use it before pushing and pulling on her to shove her out of that car and leaving her on a country road, and took off with the car, the purse, a dog, and then bought 4 cell phones with her credit card. And then go joyriding in the car with not a care in the world. The fear and trauma this has caused on my aunt is horrible. She has lost all trust in people and now lives her life in fear. What you and your friend did shows your character and who you are as a person, which is downright cold with no feelings at all. I hope you take the time away to reflect on your life and all the lives you have hurt along the way. I also hope your grandma, mom, daughter, aunt, or whoever it may be never has to go through this scary, traumatizing experience that my aunt had to live through and continues to deal with every day. That's what I had to say. I'm done.
Very well. Thank you, ma'am. If you'd go ahead and mute yourself again, please.
Oh.
All right, I see that they have muted themselves. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence. Ms. Norris, at this time, the state may make any formal sentencing recommendations.
Thank you, Your Honor. Regarding count 1, the kidnapping, would ask the court assign defendant to the mid-range guideline sentence of 216 months in the Department of Corrections. On count 4, the aggravated robbery, 59 months in the Department of Corrections. And regarding the criminal threat, 6 months in the Department of Corrections. Overall, defendant would be able to earn up to 15% good time credit and would be subject to 36 months of post-release. As previously discussed, this is a registerable offense, although defendant will not need to register while in custody, but upon release. She has earned 269 days of jail time credit as of this date. Your Honor, we'd ask the court assess the cost of the action to the defendant. The court will need to make findings regarding the court-appointed attorney's fees and the bid's application fee. There is no request for restitution, and state is not requesting a fine as a condition in this case. Otherwise, Your Honor, I don't think state has any further recommendations for the court at this time.
Norris, what's the state's position regarding consecutive or concurrent sentences on the 3 counts?
Your Honor, in keeping with the plea negotiations, it does appear that we discussed concurrent mid-box, follow the presumption, and that was via email prior to the plea on February 21st.
Very well. Thank you, Ms. Norris. Mr. Watts, at this time, I would ask you as defendant's counsel to make recommendations regarding an appropriate sentence.
Your Honor, as to count 1, we'd ask the departure to half what are the otherwise granted sentence for the reasons previously noted. I would note, response to Ms. Norris, and I think something mentioned in court at the time we set the plea deal. We set not the plea, but the trial date where it was in February from a October preliminary hearing, in large part in order to attempt to find the alibi witness that the state believes is fiction. Moreover, I am not required, nor would I, inform a defendant of any potential alibi witness until that witness is actually secured. As to the matter in Jackson County, I understand that's the state's position. I have no knowledge of whether that's accurate or not. In any case, as to the aggravated robbery, would ask the standard mid-range in that case, we'd ask they run concurrent pursuant to the plea agreement. with count one. And as to criminal threat, the standard mid-range, and again pursuant to the plea agreement concurrent to count one as well. I don't think I have anything else to add, Your Honor.
Very well, Mr. Watts. At this time, the court will address the defendant, Wendy Sincere Scott, personally, and the court will ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she personally would like to present. Ms. Scott.
First off, I'd like to apologize. I never got the opportunity to apologize to Ms. Zilke of any of these crimes that was committed. Every time I was in court, I basically let my defense attorney talk for me. But from the bottom of my heart, what I was involved in, I do apologize for that because I know I was in the wrong and I was very drugged up, but I don't want no oh poor me situations like I explained to my defense attorney. It never was oh poor me. I do apologize to Ms. Zilke for everything that was committed, that she was harmed. But what I had something to do, whatever I did in the situation, I do apologize for that. And don't nobody should have to, go through anything like that. So that's what I like to, inform. And that's all I like to say, Your Honor.
Very well, Ms. Scott. At this time, the court will pronounce sentence. Ms. Scott, it would be difficult for this court to listen to a victim statement like made by Beverly Zilke and not feel some level of compassion for this elderly woman and what she went through. The actions of yourself and your co-defendant in the view of this court were utterly reprehensible. This is a woman who tried to reach out to you with kindness based on what she perceived was a legitimate medical issue. And in return, what she got in response was deceit, violence, and theft of her car. It would be difficult to imagine a more severe situation for these crimes than this. I think that we all should feel fortunate that Beverly was not hurt even more than what she was. But the court, considering all factors in the case, first of all, we'll just make a finding here for purposes of the record that the court, having considered the entirety of the motion for durational departure and all of the reasons which are stated and have been argued by Mr. Watts in this case, the court finds that there are no substantial and compelling reasons that would justify a departure sentence in this case. With that said, the court hereby establishes count one as the base sentence for the offense of kidnapping, a severity level 3 non-drug person felony, in which this defendant has a criminal history score of B, thus placing her in grid box 3B. The court hereby sentences the defendant to a term of 216 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. The court imposes no fine on that count. Regarding the additional offense of aggravated robbery, a severity level 3 non-drug person felony, in which the defendant has a criminal history score of I, thus placing her in grid box 3I. The court hereby sentences the defendant to a term of 55 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. No fine is imposed on that count. Regarding the additional offense of criminal threat, a severity level 9 non-drug person felony, in which the defendant has a criminal history score of I, thus placing her in grid box 9I. The court hereby sentences the defendant to a term of 5 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court imposes no fine as to that individual account. Ms. Scott, with this court's finding that this was a terrible, avoidable, reprehensible crime, this court will run the time on counts 1, 4, and 3 consecutively with one another. This court of the belief that each one of these offenses constitute a separate criminal and violent act involving Beverly Zielke. And therefore, each one should be punished separately, and the court will run all 3 counts consecutively with one another. Doing the math here, the 216 months on count 1 is run consecutively with the 55 months on count 4. That would add to 271 months. There is an additional 5-month sentence on the criminal threat, which makes a total sentence of 276 months in prison. Ms. Scott, the primary controlling post-release supervision period is 36 months. No fines are imposed. However, the court will assess a felony docket fee in this case. Further, there is a statement before this court that indicates that there was a $1,000 in loss to the victim, Beverly Zielke, in this case. Whether the state's requesting restitution or not, this victim is entitled to it. So the court will be ordering the defendant, joint and several with any co-defendant, to pay $1,000 in restitution to the victim. Court declares that all amounts that have been assessed in this case are immediately due and payable and may be collected through the court's collection agency if necessary. Regarding jail time credit, the court does award, and the sentencing journal entry should reflect 269 days of jail time credit that the defendant is entitled to for being incarcerated prior to today's sentencing date. I will advise the defendant of her obligation to register as a violent offender under the Kansas Offender Registration Act. Court does find that with the crime of kidnapping in this case, that the period of registration in this case is for lifetime, which means all times that you're not incarcerated, you're going to have an obligation to register as a violent offender, Ms. Scott. At some point in the future, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. Ms. Scott, if you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered.
Remember, guys, she's 40. With good time credit and early release and everything like that, she's going to be lucky to be 60 by the time she's out.
Under certain limited circumstances, a criminal defendant may have a right to appeal a conviction or convictions to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, Ms. Scott, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence. If the court has ruled adversely to you at this hearing, I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, are you aware of any other sentencing-related matters that the court has not yet addressed?
No, Your Honor, thank you.
Mr. Watts, are you aware of anything further?
No, Your Honor, thank you.
I do want to make sure, though, I think it could be implied from the record, I want to make a specific finding that based on the court's incarceration order, the court's waiving bids assessments in this case. The defendant just doesn't have the financial resources to reimburse those amounts. This time, the court places the custody of Wendy Scott back into the jail under the custody of the Butler County Sheriff's Office until her custody can be transferred to the Department of Corrections to serve the remaining balance of the prison sentence, which the court has imposed here today. If there's nothing further, the Wendy Sincere Scott matter will currently be in recess, and this meeting may be ended for all at this time.
Okay, Mr. James. Can we talk? Can they get out of here?
And now we're going to go back in time just slightly. Or, well, no, a couple days ahead. Well, anyways, now we're going to see her co-defendant. I didn't have all of the preliminary examination and evidentiary hearing and everything like that, like I did for the first defendant. But all of the evidence is the same. All the witnesses would have been the same. We'd have just been watching a duplicate case. But we do want to see the sentencing.
I think the next case that I have is Miss Rogers, and I've got Mr. Paul, but I've got, is it Jorge?
That's right, Your Honor.
De Hoyos?
Yeah, De Hoyos.
Say again, my Spanish isn't very good.
So it's Jorge De Hoyos.
And Your Honor, she's at the jail, so we're gonna have to wait for the jail to get back on to take up Miss Rogers.
Yeah.
Thank you, Amber. Let me just go ahead and practice Jorge De Hoyos.
Perfect.
Okay. Okay, before proceeding with the final case set on the docket for sentence, I'm going to ask Jorge, do you want to meet with Miss Rogers, or are you prepared to go ahead and go to sentencing?
If you want to give me a quick couple minutes with Miss Rogers, I would appreciate it.
Okay, give us just a moment. Belen will try to set up a breakout room for you, and then we'll come back with sentencing.
Yes, sir. Thank you, sir.
And everyone will be in recess until we come back for sentencing with Miss Rogers.
Okay. Where is Miss Norris?
I'm here, Jorge.
Hey, I want to make sure that the plea agreement on this one was free to argue, wasn't it?
Yes, you're free to argue, but state's
Okay.
not joining.
No, that's fine. I just wanted to make sure I didn't offend any part of the plea agreement by arguing or filing the departure motion.
No.
Okay. Well, thank you. Otherwise, me and Miss Rogers are good to go.
All right. We will go on the record, the Zoom record. Case is entitled State of Kansas versus Elizabeth Rosa Rogers, 24 CR 465. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Ms. Rogers, appears in person and by court-appointed counsel Jorge De Hoyos. And also appearing at this time is Court Service Officer Tony Bauer. This matter does regularly come back before the court this date for sentence. In anticipation of sentence, the court has ordered a pre-sentence investigation report. The court has received the same. I trust the counsel for the state and the defendant have received a copy. And before proceeding any further, is there any objection to the criminal history as set forth, which does indicate a criminal history score I as in ice? Ms. Norris
No objection, Your Honor.
and Mr. De Hoyos.
No objection, Your Honor.
Court finds no objection to the criminal history as set forth. Therefore, it does become part of the basis for sentence herein. Before proceeding to sentence, the court will listen to recommendations from respective counsel as to appropriate sentence, beginning with the state and Ms. Norris.
Your Honor, there is a motion to depart that was filed by Mr. Hoyos. And then also the victim is present and will want to address the court, and possibly one of her family members may also want to address the court.
Thank you, Ms. Norris. The court will proceed with the departure motion by the state. by the defense and Mr. Hoyos.
So, Judge, in this matter, I have filed a departure motion for a number of reasons, not the least of which is the incredible youth of my client. At this time, she's 19 years old. And Judge, I'm 37. I can tell you 18 years ago when I was 19, I was making terrible mistakes too. And if somebody hadn't taken mercy on me, I would not have become the criminal defense lawyer I am today. So I think sometimes people her age have to bounce off a rock bottom, but should not be left there. Instilling a probation agreement today or a probation sentence today allows you to demonstrate to her the power this court has over her because she just spent the last 8 months in custody. She understands any mishap on probation means she's looking at substantial prison time and she's only 19. Now, in this matter, there was a co-defendant. That co-defendant was in her 40s, and that co-defendant has a significant criminal history, the kind of which that Ms. Rogers has no business getting anywhere near. But by putting her faith in Ms. Scott, Ms. Rogers ended up in a terrible place in a terrible way. And Judge, for all these reasons, and not given just her lack of criminal history, lack of a juvenile record, her age and immaturity, and the fact that there was a co-defendant who played a significant role in the matter, I think you have a young woman here who can learn if given the opportunity. But we have to make that decision today. So, Judge, I'm imploring you to issue a probation sentence in this matter. That probation be 36 months with whatever conditions the court believes appropriate.
Thank you, Mr. De Hoyos. And victim statement by individual. And Ms. Norris, do you know the victim's name?
Yes, Your Honor. That's Ms. Zilke, Beverly Zilke, on the screen under, looks like Gil or Gilly.
And the court would refer the court to being addressed by Beverly Zilke. Beverly Zilke.
Yes, say it.
Yes, yes.
Good afternoon.
Good afternoon.
And statements to the court, Miss Beverly Zilke.
Yes.
Would you like to state anything to the court?
Well,
This is your opportunity.
what do you want? I don't understand. I've never done this before, so what?
That's a good thing. You haven't ever done this before.
No.
That's a good thing. What would you like to advise the court in regards to the crime that you were a victim in regards to the defendant? Her name is Elizabeth Rosa Rogers. What would you like to tell the court? This is your opportunity.
Do I tell them what happened? Is that tell them the story of what happened through me?
That's fine. Yes, ma'am.
All right, I will do that. I'll start from the beginning of that day. She called me because she lived down the hall from where I live in the same apartment building. And she asked if she could come and borrow a cookbook. And I said, yes. And so I thought I was waiting for her to come to my house, which was just down the hall. And the door knock came and I thought, oh, there she is. But it was a friend of hers, her friend. And she said, is she here yet? And I said, no. And she said, could I come in and wait? She said she would be here. And I said, well, okay. And she came in and sat in the living room. And about 5 minutes later, I can't even, her name is Elizabeth, right? Elizabeth showed up. And I took her in the back room where I had a bunch of I have a collection of cookbooks, so she sat down and we started looking.
Don't worry about her name, Beverly. She's not worth remembering.
Me and her friend went in the living room and sit and talked, and then her friend, and I can't, Wendy, her name was Wendy, her friend, and she said, let's go back and see what she's doing, or I'm going back and see what she was doing. I said, okay. So she went back, and I waited about a few minutes, and I thought, I'm going back there too. I went back there, I took a hold of the door, and it was locked. And I thought, well, what's this? And I went and reached the door again, and it was unlocked. So they heard me turn the lock and unlocked it. I went in, and Elizabeth was looking at the cookbooks and pointing out different recipes and talking. And all of a sudden, she started rolling on the floor and saying, oh God, my stomach, oh. And Wendy said, oh, she's been to the hospital before for this. She needs to get to the emergency room. Could you possibly take us? And I said, well, okay. I'm babysitting my daughter's dog because my daughter went on a cruise, and I'll take her with me. And they said, that's okay. So we all walked down and got in my car, which was a brand new car, and it still had the paper tag on the back. I hadn't even had a chance to get a car tag. And we started, and I didn't know where what emergency room they were headed for. So I said, you'll have to guide me. I don't know where to go. And they said, that's okay. We'll do that. And we got on the highway, went to Kellogg, went down, and there's a little town just outside, way east of Wichita, Andover. And I thought that's where we were going, to emergency room there. And there's two stoplights before you hit one, and there's a filling station across the street. And then you go up the next one and you hit Andover. And I was going to go straight on, and Wendy said, no, you turn here on the first turn. And it took me on a country road, and we drove and drove and drove on the country road. And I said, well, where is this place? Where is it at? And she said, it isn't too much further. And we drove and drove, and I had taken my daughter's little dog with me, and she was standing, she had her little feet on my leg and had her little paws on the window looking out. And then all of a sudden we kept driving, and I just stopped the car in the middle of the country road. And I said, we've been on the highway, we've been driving a long, long time. You told me this wasn't very far. We've gone a long way. How much further is this place? And at that point, that Wendy got out of the back seat, and she yanked the door open, and she said, you give me your car and your purse. And I said, no, I won't do that. That's my car. It's my car. And it was brand new. It still had the paper tag on it. And I had my purse. And she said, give it to me. And I said, no, I won't do that. It's my car, my purse. She started pulling on my arm, and she had long fingernails. And I kept yanking my arm, trying to get it away. And Elizabeth was shoving on my back to shove me out, and the other girl was pulling my arm to pull me out of the car. And I had my hand on the steering wheel, and my feet was braced on the floor trying to stay in the car. And they kept shoving and pushing, and both of them. One was pulling my arm, and Elizabeth was shoving on me on my back, trying to shove me out. And I won for a long time, but finally I wore out because I am 87 years old. And they threw me in the dirt on the country road, and sped off in my car which it was a new car. I still had the paper tag on it. And I didn't know where Chloe was, my daughter's dog. And I kept looking and looking, and I finally walked down the country road and I went to a farmhouse. There was no one home. So I kept walking down the road to the next farmhouse, and there was a man there, and he said, "Oh," and I said, "Could I please borrow your phone? My car and my purse was stolen, and I was thrown out of my car on the country road." And I said, "I need help. I need to have the police come." And so he said, "Oh my goodness." And he went in and called the police, the ambulance, the fire truck, I don't remember what all showed up. The sheriff, the policeman, they all showed up at this farmhouse, and they wanted to know if I wanted to go to the hospital. I said, no, I don't want to do that. I want to find my daughter's dog because I'm scared. They took my daughter's dog. I don't know if she got out of the car or not. And I said, and my purse and my car is brand new. They took my car, and so anyway, the police started looking for the dog to see if it was, because I didn't know if they took my dog or not, the dog. And then the sheriff, some of the others then finally left, the ambulance and all of the other things, the police and and the sheriff said, "Well, why don't we get in the car and we'll go to my station?" And I said, "That's fine." So I got in the car with him and went there, and we were there till early hours in the morning. And I don't remember, he had 5 or 6 TVs with all the police in the city were looking for my car, and they were making reports on all of those 5 TVs that he had in his office. And he finally said, "You know what? We're not going to find that tonight. Why don't I take you home?" And I said, "Okay." And that was probably about 3 o'clock in the morning when he finally said that. And this happened at 4 o'clock in the afternoon, when they did all of this. And I was with him till 3 o'clock in the morning. And I said, "Okay," because I'm so tired and haven't eaten, and I need to get home. And so we got ready and was at the door and just opening the door to go out into my car, into his car, the sheriff. And he got another beep and yelling on the TVs. He had 5 TVs in that other room that police were reporting every time they saw a Nissan car like mine. And he said, "Oh, there's let's run back. I've got to get this." And he ran back and he says, "They found her. They found the car." He said, "We'll get in the car and we're going to go to where it's located. They've located it and the police are there now." And I said, "Oh, good." So I went with him. I drove with him, rode with him to the place, which they had picked up Wendy. And I sat in the car like 2 hours or something while they were taking pictures and doing all kinds of stuff. And then he took me home, and they said they had found the car, and I did forget to say, when I was there, that Wendy threatened, she held her purse up in the air and she said, "Do you see my purse?" And I said, "Yes." And she said, "Well, I have a gun in it. I have used it before, and I'm not afraid to use it again, and I will." And well, then they threw me out in the dirt and took me off in my car. And So anyway, then he finally took me home about 6 o'clock in the morning because it took all that time, whatever they did at that house, when they picked up Wendy with my car at that point. Oh, I don't know what to say now. That's what happened. I'm telling you what happened.
Okay, thank you. Ms. Zilke, the court would be interested in your perspective on whether the defendant, Ms. Rogers, whether the court should grant the motion for probation, whether you're advocating for a prison sentence. How do you wish for the court to dispose of Ms. Rogers?
I think that she deserves to go to prison.
How should we dispose of Miss Rogers? Well, tarps, shower curtains, wood chippers, plenty of options.
Because I was very good to her. I was very kind to her. I didn't really know her, but she lived down the hall from me, and she did all of them horrible things. I never did anything at all. I just always, I said hi when I saw her, because we both had cars in the parking lot. I saw her when I'd go out and get in the car, and I'd always say hi. I mean, I was very nice to her. It was never not nice. I've never done anything like that in my entire life. I've never been in a police situation in my life, and I'm 87 years old.
Thank you, Ms. Zilke. And further recommendations as to sentence and defendant's departure motion by the state, Ms. North?
Your Honor, just real quickly, is there a member of Ms.
Yes, Wendy wants to, yes.
Yes, Wendy wanted to speak.
Okay.
Excuse me, and there's another statement for the victim to be made. And ma'am, if you could please give your name and relationship, if any, to Miss Zilke.
My name is Wendy K. Dwyer. She is my Aunt Beverly. I'm her niece.
Thank
And
you.
let me start.
Please proceed.
First of all, I want to ask Elizabeth, what the hell were you thinking that day to take advantage and threaten an elderly 87-year-old lady? I need you, Elizabeth Rosa Rogers, to understand
Judge,
how
I have to
horrific-
intervene here. Judge, it is not proper for anybody to address my client except me and the court. By law, the witness is allowed to address
I
the
did it
court.
with Wendy.
Judge, forgive me. Judge, I'm asking that direct questions to my client
I'm not
be
asking
prohibited.
questions. Oh, okay. That was a statement question.
The court does sustain the objection by Mr. De Hoyos on behalf of the defendant herein, his client. The court would ask that you just address the court, please. And once again, could I get your name? It's Wendy and the last
Dwyer,
name.
Dwire.
Thank you, Ms. Dwyer. Please proceed.
Okay, I need her, Elizabeth Rosa Rogers, to understand how horrific the crime her and her friend Wendy Sincere Scott committed really was. I do believe you was the mastermind behind the whole plan, and then you included your friend Wendy. I feel this because you had recently, days before, befriended Beverly when you were crying about losing custody of your baby for certain reasons, and you asked her about cookbooks. For some reason, you sent Wendy to her door first, and my aunt had never met Wendy prior to this incident. Then a short time later, you showed up to the door and went into the room with the books and closed the door.
Please
Leaving
proceed,
Wendy.
Miss Dwyer. Please proceed a little bit more slowly in
Okay.
case the matter would need to
Okay.
be
Okay.
transcribed at a later date. So
Okay.
please
I'll start that.
proceed just a
Okay, I'll
little
start
bit
that
more
paragraph
slowly.
over. Okay. I
Thank
do
you.
believe you was the mastermind behind this whole plan, and then you included your friend Wendy. I feel this because she had recently, days prior, befriended Beverly when Elizabeth was crying about losing the custody of her baby for reasons, and then asked her about cookbooks. For some reason, she sent Wendy to her door first, and my Aunt Bev had never met Wendy prior to this incident. Then, a short time later, Elizabeth showed up to the door and went into the room with the books and closed the door, leaving Wendy with Beverly. Then eventually, Wendy got up and went into the room with Elizabeth, and also shut the door. When Aunt Bev decided to see what they were doing, the door was locked and then instantly became unlocked. After Beverly entered, Elizabeth was the one who faked the horrible stomach cramps and said she needed medical attention and needed a ride. She also stated her insurance was only good at one medical facility in Andover, Augusta. I'm not sure. This put the three of them in the car, including Chloe, her daughter's dog, whom she was dog sitting for. This is where Elizabeth's plan included stealing her car and purse. She was threatened and injured while being pushed and pulled and shoved out of her car onto a gravel dirt country road. She lay there watching as her car, her purse, and her grand dog baby, whom she loves, took off without her. Then you all went joyriding with boyfriends and shopped using her credit cards. The fear and trauma this has caused on my aunt is horrible. She has lost all trust in people and now lives her life in fear. What you and your friend did shows your character and who you are as a person, which is downright cold with no feelings towards others. I hope you take this time away to really reflect on your life and all the lives you have hurt along the way. I also hope your grandma, your mom, your daughter, aunt, or whomever you may care about never has to go through something this scary, traumatizing that my aunt had to live through and continues to deal with every day. Judge, her partner Wendy received 23 years, and I don't know if she should get that much time, but she definitely deserves time. Time enough she really thinks and feels what she did was wrong, and she needs to change her life and maybe work on getting her child back.
Thank you, Ms. Dwyer. Further
Yes, please.
victim statements. Any further victim statements
No.
that you may know about from the state?
No, Your Honor.
Ms.
Thank you.
Norris?
No, Your Honor.
Thank you. And recommendation as to sentence from the state, Ms. Norris?
Your Honor, state recommends on count one, the kidnapping, 55 months in the Department of Corrections. Defendant would be able to earn up to 15% good time credit and will be subject to 36 months post-release. And Your Honor, this is a registration required offense. And Your Honor, regarding count three, 31 months in the Department of Corrections for mistreatment of a dependent adult. And on count four, criminal threat, 5 months in the Department of Corrections. In keeping with the plea agreement, state recommend that those counts run concurrent and that the court follow the presumption of prison. Defendant has earned 247 days of jail time credit as of this date. Ask the court assess the cost of the action to the defendant. Court will need to address court-appointed attorney's fees and the bid's application fee. And Your Honor, there is restitution joint and several with the co-defendant of $1,000. And that relates to charges made on the cards, et cetera. And Your Honor, the co-defendant was ordered to pay that in her case in front of Judge Ricky. And Your Honor, regarding the motion to depart, state is not agreeing, and actually it opposes the request that counsel makes on behalf of the defendant. Your Honor, the defendant doesn't have any criminal history, but these crimes, the kidnapping, mistreatment, and criminal threat are all very serious. All are person crimes. And as Ms. Zilke already said to the court, she's 87 years old. These were this was a very calculated situation. It was planned. It was executed. She was injured in the process. Your Honor, I see no substantial and compelling reasons to depart for these types of crimes. And yeah, it is unfortunate that she really doesn't have any history and that she is so young, but she made these decisions, she made these choices, and Your Honor, she should be held accountable. And we would ask the court deny the motion to depart to probation, and that the court send the defendant to the presumptive sentence of at least 55 months in the Department of Corrections. Thank you.
Thank you, Ms. Norris. And recommendation as to sentence, Mr. De Hoyos.
So, Your Honor, first of all, let me express my sincerest condolences to the victim and to her family. I firmly agree that nobody should have to go through what they endured, and I pray that nobody ever does. That being said, Judge, if you told me that you sent somebody to prison for kidnapping and mistreatment of an elder person, I think everybody on God's green earth would tell you they're not surprised. But if I told you that the state paid for an education, and that education was 4 years prison as opposed to 4 years at a state university, I think all of us would be looking at each other going, what are you talking about? $33,000 a year is what it costs to keep somebody in custody. So if the state gets what they want, it's $130,000 being spent to house Miss Rogers. Now, we do have to have a cause and effect on her. We do have to punish her so that she understands our society has limits and has limitations. And I can appreciate why nobody else besides me, Miss Rogers, might be asking for her to go to probation. If the court is going to insist on a prison time, we should do something that is appropriate and perhaps even proportional to how long this child has been alive. To that end, Judge, I'd ask that if you're not going to consider probation for Miss Rogers, then perhaps you should consider half of the called for number at 55 down to, what would that be, 27 months. That's still 2 years plus of prison time that Miss Rogers gets. It's 10%
Anyone's time served.
of her
No.
life right now.
3 months. And he's put
The victims are not unmuted. There you go. Sorry, Judge. That's still 10% of this young woman's life. It will provide a substantial, compelling reason not to ever find yourself in this kind of trouble again. But I don't think that we gain anything with 4 years against Miss Rogers as opposed to putting her, if necessary, in prison for long enough for the message to stick, but not long enough to ruin her life.
Did he seriously argue that we should consider 4 years of college for her instead of 4 years probation? Because it's the same cost? I mean, essentially, that's what he's doing. Are you kidding me? She's a violent thug. And she could have unalived that poor old lady. He is so slimy. And his mic is terrible. It drives me nuts. I hate that crackling sound from him.
Thank you, Mr. De Hoyos. And Ms. Rogers, prior to the court pronouncing judgment and sentence upon you, Is there anything you would like to state in mitigation of your sentence?
I would just like to say that I do apologize to Miss Zelke about everything that happened, and it honestly was not a planned thing. I didn't know that it was going to happen, and I should have done more to help you, and I apologize that I didn't. I'm really sorry about, just my choices as a person and as a human being because I made poor choices, and I'm sorry. I just hope that you accept my apology and hope that you know that I am a good person, and I don't think that I deserve probation. I think that I do deserve to go to prison because what happened was just horrible. And if it happened to my grandma, I would feel the same way. And I would feel like, I would feel like that person that did it to my grandma would deserve to go to prison for the rest of their life. Even though I don't think I deserve that. I'm 19 years old and I made a bad decision and I understand that. And I understand that there's repercussions to that decision. And I just hope that you guys have mercy on me, please.
Thank you, Ms. Rogers. Do you know of any reason why the court should not pronounce judgment and sentence upon you here today?
No.
And Mr. De Hoyos?
I have no known reason, Judge.
Ms. Rogers, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 55 months in prison. This is as to count 1, kidnapping to facilitate flight or commission of a crime, severity level 3, person felony. Count 3, the court sentences you for mistreatment of dependent adult or elder person to 31 months in prison. On count 4, criminal threat, severity level 9, person felony, court sentences you to 5 months in prison. The court does run those sentences concurrent, all at the same time. Subsequently, the court has taken into consideration the departure motion that has been filed on your behalf in the case and argued by Mr. De Hoyos here today. The court does overrule and deny the same. The court does advise you that this is a registration offense and you do need to be in compliance with that registration. The court does run, once again, all these sentences concurrent to each other at the same time.
Keep in mind with her, one, the charges are different, right? She, though she was the one who faked being sick in order to coerce the victim into taking them to the hospital, she wasn't the driver of the vehicle. So she didn't get the grand theft auto to the level that the other one did. Plus, she has no criminal history, whereas the other one 5 years ago had another violent attacking offense similar to this one. So the criminal histories are different and the charges are different. So he can't give her the 23 years that the other gal got. It's her first offense.
It would appear to the court that there have been some considerations given to you in regards to the use of mitigated numbers in your sentencing. The standard sentence herein would have been 59 months, and the mitigated sentence is 55 months. And that's what was recommended That's what is adopted by the court here today. Also, the state could very well have requested the court to run your sentences consecutive to each other, which would have added approximately 36 months on top of the 50, 55 or whatever the base sentence would be. That did not happen. This was concurrent sentencing herein. The court does order restitution in the sum. I believe that this is correct. Correct me if I'm wrong. $1,000 in restitution for use of credit cards.
Correct, Your Honor.
Thank you. And once again, the court is finding that there have not been substantial and compelling reasons presented to the court to grant your departure motion. Subsequently, pursuant to KSA 22-3608C, the court does advise you that you shall have 14 days after the judgment of the district court to appeal your sentence. The court advises you pursuant to KSA 21-4619G of any expungement rights you may have. And the court does advise you of your prohibition of possession of any firearms. And once again, the court does notify you of your duty to register herein. Any other matters to come before the court? Ms. Norris?
Your Honor, I assume that you're waiving attorney and bids fees.
The court finds that Ms. Rogers, due to her incarceration, will not have the financial wherewithal for reimbursement of court-appointed legal fees, nor the bids application fee. Any other matters, Ms. Norris?
No, Your Honor, thank you.
And Mr. De Hoyos?
No, Your Honor, thank you for the court's time.
Your Honor, because there's restitution, the court has to set basically a payment plan, or you can also order that they be immediately due. But the court does need to make some sort of a ruling regarding repayment.
That's fine. There's going to be a substantial, there's jail time credit at 247 days. So that's about, I think, 8-9 months. I think it'd be appropriate to repay this at $50 per month. $50 will be the order of the court for reimbursement of restitution for the $1,000 that was wrongfully used as from the victim's credit cards.
And Your Honor orders that joint and several with the co-defendant.
So ordered.
Thank you.
Yes. Ms. Rogers, good luck to you. It would appear to me that the state, your counsel, have negotiated a plea herein, presented the same to the court. It appears to be a reasonable sentence based on what occurred. I wish you well, and I hope that your life does improve from this, what it must be a very low point. There being nothing further to come before the court is in recess. Good luck to you.
Judge, I think that's all I had on your docket. I think it actually completes your docket. Is that right?
Yes, that is. Jorge, it's nice to meet you.
So we got to see both of them. And yeah, like I said, if it wasn't for the fact that it was her first charge, she probably would have gotten hit a lot harder. But as it is, She got the book thrown to her for as much time as he could give her, with the exception of he ran it concurrent and not consecutive. Whereas Judge Ricky, he ran it consecutive. Jimmy James, how you doing, sweetie? Oh, you have summoned the Ava. Yeah, no kidding. You're welcome. Oh my gosh, I'm so glad that you guys came out and enjoyed it with me. Yeah, so oh, he is, and I love him. I love him so much. I'm so happy you guys liked it. I am really, really sorry about my internet connection pooping out and looking like dial-up for a little bit there. I'm gonna reset my router as soon as I reboot, but it's on full bars. Oh nope, it's one down, which is crazy because I pay extra for the higher speed, because there used to be the hobosexual had his PS5 hooked up out there. So yeah, I have the bigger package for it, and it shouldn't be slow. It shouldn't lag. It shouldn't diminish the quality of the video when I stream. So, and plus, when I bought my computer, I bought one of the fanciest streaming routers that they had. So I don't know. I'm going to have to try it again. Yep, Patrick B, I've already been alerted. It is actually a real term. Dana M said it in the stream one night, and then I made, hold up, I'll show you what I made. Give me 1 second here. Image. Hi, Earl. Meow. Meow. Yep, I made that. I love you, C-Rex. Yep, yep. The term actually means a man who, well, I guess it could be a woman too, a partner that only gets into relationships with people to mooch off of them, basically. Like they seek out victims, more or less, for places to live, and they don't have their own place. They just get into relationships for housing. And that's essentially what he did. And this is the third time I've let him live with me. And yeah, he's such a piece. So anyways, that's a thing now. If I can ever find a way to get a merch store going, then that'll be available. If you want it prior to me having a merch store, you just got to email me, and I can get you a t-shirt or a mug or whatever you want, really. And I have it. Not only do I have that, do you gotta go potty? Okay, give me a second here. Give me a second. I'll close it out in just a moment. Let's say you wanted it on a gray shirt or a red shirt. I have it with transparent background as well. So, yep. Oh. Meow. 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 Finally, I said, please come put your butt in my face. All right, guys, I gotta take Ava potty. So, you just show up at the very end when I'm leaving. I love you. Yeah. Oh yeah. Yeah. You go watch the dash cam video that I posted. Good stuff. Good times. Good times. It explains it all. All right, guys. No, he has not done that. No. Everybody's probably sick of me talking about what he has done though. So, it's on multiple live streams from the day I caught him on. All right, guys, I got to take her out. I don't need to clean up that mess. Bless you. Thank you guys so much for coming out. Oh my gosh, Ava. It's always a great time here. Be safe, be well, sleep sweet, and much love.